Do we have enough?
Now
We're going to be at ease for a few minutes. We're still working on our quorum. Give me a few minutes here, folks.
Mr. Chairman, can you hear me?
Yes, I got you, Josh.
I've got some Democratic hawks I could bring in if you need a quorum.
Looks like we just got another member that signed up. I appreciate it. All right. Well, good morning, folks. Thanks for coming in today. We're going to bring this full committee of Judiciary Non-Civil together to order, and I'm going to give a word of blessing, and we'll get started. Let's bow our heads. Dear Heavenly Father, thank you for the blessing you bestowed upon us, Lord. Lord, give us the wisdom and the guidance necessary to do your bidding today, Lord. Lord, I ask all this in your Heavenly Son's name, Jesus Christ. Amen. We've got a pretty lengthy set of bills for today. We're going to do some hearing onlys, and we're going to try to get some of this that's been heard before passed out. So bear with us. Have we got a sign up sheet? Everybody that wants to speak to a bill, have they signed up? If you haven't, and we're working through your bill, just reach out, stick your hand in there, and we'll recognize you and get you in here to speak to these bills. The first bill we're going to hear is House Bill 1391, Chairman Gunter. Appreciate you going into your bill and tell us what it does.
Thank you, Mr. Chairman. Members of the committee, House Bill 1391 basically equalizes the pay of the public defender with that of the district attorney. Section 2, the line 37, the change is for the assistant public defender to earn 95% instead of 90% of the pay of a public defender. So basically, this just gives a pay increase to the public defender's office. I signed on to this, having been a former prosecutor. I understand how important the job of the public defender is in the system, even though the district attorney may handle more cases and have other duties. We need good people sitting in these positions, and I'm hoping that this will attract the good people in that. That's basically the bill.
Thank you, Chairman Gunter. Do you have any anyone here to speak to the bill or against the bill that you know of?
No.
No.
Not unless you own it.
Having passed out a subcommittee, we're going to, if there's nobody that wants to speak to this bill, is there anybody that wants to speak to this bill? I want to echo what Chairman Gunter said. You know, there's two sides, sometimes three sides when you go into a courtroom, and there's a group of folks here that represent the prosecutors, and I don't often see anybody from the public defender's office up here lobbying. So I think this is a good bill. This is good policy, and with that, I'll entertain a motion.
So moved.
Got a motion. We have a second. We got a second. We got a motion and a second. Any discussion on House Bill 1391 LC 280447? Hearing none, all those in favor of House Bill 1391 signify by saying aye.
Aye.
Can you unmute yourself online, Charlize?
Aye.
Thank you. All those opposed signify by saying no. The measure passes on the rules. Appreciate it.
Thank you.
We've got now, let's see here. Vehicles, House Bill 439. We've got Chairman Hitchens. This, I expect this. At least you're on, there you go. Yeah, we can. All right. Chairman Hitchens, I appreciate you coming today. Would you present the bill? This is the first time we've heard it.
Okay.
I'd like to dig in pretty hard and you tell us what it does and what it doesn't do.
Well, this is our fourth hearing, one last year and three this year. So I think I've come to understand pretty much what it does do. But I've got with me today Mr. Gabe Crosby, who represents Prosecuting Attorneys Council. Before I get started, I'd just like to say that, we worked on this thing for a year, and we've sent out some literature to all the members the other day, and we've made 5 pages full of corrections to this. Defense attorneys, prosecutors, the driving schools, the public, several groups like MAD have had input and made changes. And I think we've incorporated just about every one that's been made to us. And what it does is it requires, on your first offense for driving under the influence, it requires ignition interlocks. That seems to be the pushback. And the second thing it does is it provides for reduced cost for those people who are indigent. And I've got you all saw the sheet in the last hearing. One of the real obstacles was the cost. It costs for 6 months. If your first offense is 6 months and subsequent offense is 12 months that you have to have the ignition interlock. And people thought it was as much as $1,500, but the total cost is $600. And if you are indigent and you meet the criteria that they use for other means, it's up to the judge to make the determination. It would be $270. So essentially it's $3.33 a day if you're a regular person, and if you're indigent, it would be $1.50 a day. One of the big obstacles seem to be for the first offense. People think we're a caring nation. We give people second chances on almost everything we do. Criminal activity, you get probation. Playing golf, you get a mulligan. They feel like on DUI, maybe you get a second chance. Well, the Center for Disease Control and Michigan State University have done extensive studies on this. And the last one by the Center for Disease Control that's been published by the FBI says that on the average, people who drive under the influence drive 80 times before they're ever apprehended. So if we allow them to do that and get a second chance, they can drive 160 times before they ever get have to respond and have an ignition interlock. The ignition interlocks have come a long ways. There are a lot of people that believe that you can circumvent them, and certainly nothing's 100%. I've seen prisons that I thought people couldn't ever get out of that they've had escapes from, but what it does now is, as always, you have to blow in it. If you have 2 grams per cent or more, your vehicle won't start. But if somebody else blows into it, it will start. And that was one of the hindrances years back. Now, if you blow into it and somebody blows into it and you start it 3, 4, 5 minutes later, it will require a second test. And if you fail the second test that you did yourself, if you're drinking, it will slowly reduce your speed and you'll have to drive over and stop, and you'll have to get somebody to come and assist you. So it's had great results around the country. In fact, 34 states and the District of Columbia now all do this on the first offense. And you can see from one of the brochures that May had provided with me, some of the states, Mississippi had 19% reduction in DUI fatalities, Arkansas 25%, Oklahoma 29%, Kansas 32%, Arizona 34%, Vermont 40%. Delaware 40%, Louisiana 41%, and West Virginia 60%. Typically in Georgia, we kill about 1,700 to 1,800 people a year in traffic accidents. Almost consistently, 30% of those are people that are driving under the influence. So if it's much short of this and we only had 10% of those 600, we would save 60 lives a year, which to me seems pretty astronomical. And you know, my belief has always been that public safety is the first requirement of our government. I mean, the safety of our public, and this goes a long ways, I believe, to trying to do that. It's there are now 349,030 interlocks in use in the United States. This wouldn't be something that would be new and innovative. It's been done all over the country, but and that's pretty much. I'd be glad to answer any questions or ask Mr. Crosby if he has anything to add. It's I've got a volume of information, but I'd be here all day if I continue to talk.
Mr. Chairman, I appreciate your testimony. This is the first time I've heard an interlock bill in this committee, and I know you've been extensively working on this. So please don't take any of my questions for.
Well, I'm not. You know, I worked 43 years for the Georgia State Patrol and was commissioner, and I've dealt with this. And you're standing out there at 2 o'clock in the morning, and the weeds and the mud and the dirt, and you got a body or two around you, and you pick up arms and legs, and you know that you're going to have to visit somebody's home and tell a family that their innocent child, spouse, relative, friend isn't going to be coming home. It's and you do that repeatedly over the years. It makes an indelible impression on them.
I can imagine.
And just for the committee's note, Representative Holcomb is on the committee, but I didn't know it going in, but 2 members of the committee in public safety had fathers who were killed by drunk drivers.
That's awful. I've got, do we have any questions for Chairman Hitchens? We got one light flashing. Representative Montana.
Thank you, Mr. Chairman. First of all, I want to thank you for bringing the bill. It's such an important issue. You know, you said the 2 fathers. I had a very good friend of mine who was in elementary school who was going to school one morning and was T-boned by a drunk driver. And that was, I think, as a child, my first experience with the loss of somebody of whom I'd known well. And it was, it definitely changed my life. It makes a big impact when that happens. So first of all, thank you. I do have a few questions. I think this is a big bill. It's over 30 pages. It's probably one of the largest pieces of legislation that I've ever seen here outside of a select few. And so I think it's worth going through and making sure that we get this right. The first question I had was on the hardship permit. Can you tell me more? I have questions about those kind of indigency hardship waivers. Can you tell me a little bit more about that process and what it all entails?
Well, I think if your income is like 110 or 15% of what it requires for a free lunch in school.
Okay.
But the judge makes that determination.
Okay.
As he does in other cases.
So my concern is that if somebody can afford to purchase a vehicle, purchase insurance and gas at $4 a gallon, today I saw that this morning. A friend sent me $3.99 a gallon, and that was for regular. Mine takes premium, so I'm nervous to get to the pump this afternoon. And they can buy alcohol, right, of some sort, whether that be liquor or wine or beer, spirits, whatever it may be. I don't drink, so I couldn't tell you what they are. I just have a deep concern that we have that here, and I understand the reason, but if they can afford those things, I would posit to the committee that they can probably afford these devices. Has there been any consideration for that? Obviously, driving is a privilege and it's not a right. We have established that over the past probably 2-3 decades. And so with that context, can you tell me how do you feel about that?
Well, and I drink probably a beer a month. Every time I grill out, I probably drink a beer, but that's about it. I have no idea what a beer costs in a bar. My guess is probably $3 or $4. And today's inflation society, but, and that's my feeling. And, you know, the manufacturer gives back $30 to the Department of Driver Services so that they can handle the administrative work on this, on every one that they install. So, you know, I think there seems to be some feeling that the manufacturer is making a lot of money off this, and, you know, they may be making some, I'm sure, but that's the American way, and it's capitalism. You don't go into business if you don't make money, but I don't think they're getting rich off of it, because I know how much it costs to work on cars, probably $120, $130 an hour to get any type of work done on your vehicle. And some of these new cars, it takes them an hour to 2 hours to install these devices. I know on Mercedes, they have a cover off on the bottom, and they've got to remove that to get in to be able to do it. So I don't think they're making a fortune off of it, but, you know, we all remember this is self-induced. Nobody makes them go out and drink, makes them go out and drive. I know a lot of people are addicted to alcohol and they just can't stop. I've seen them time and time again when they get caught, they get their license suspended, they drive on a suspended license. I think the National Traffic Safety Council says about 60 to 70% of the people that have their license suspended continue to drive. After the second time you get caught, the first time you get caught with your license suspended, they take the tag off your car. Well, people put other tags on them, or, you know, it used to be before we got so strict about it that they would put a tag in there that said tag lost.
Sure.
But the main, the most effective means for catching those people is road checks. People wonder why they do road checks all over the state. I think the first year we really did it back about 15 years ago, we caught 3,800 felony warrant people who were wanted for felony warrants. But you catch a lot of people that are intoxicated. You catch a lot of people who have suspended license that you wouldn't catch otherwise. But they just can't help themselves. You know, they may stop and say, I'm gonna drink one beer or one drink, and they get in there and they just 2 or 3 hours later they walk out and they think, once again, some people think they can drive better when they're intoxicated. I watched tests. I mean, and even though they feel like that, their physical ability is greatly diminished. The more you drink, the worse it is. I've taken people out of cars that could not stand on their own 2 feet, that you had to help them and they're driving down the road. So,
Well, let me ask, so with that being said, the fee structure for the indigent waiver, can you give us a breakdown of that? I know you said there's indigent, give me a breakdown. Who's actually paying for the costs of the indigent? Because I know you had mentioned the manufacturers. Is it the manufacturer, or is it the installer that's paying it? And who's paying for the labor of the installation?
the manufacturer actually pays for it, and then they reimburse the installer. My guess is that the installer charges more than the $75 that the manufacturer pays. I mean, if it takes an hour, they're probably going to charge the standard rate, $120, $130 an hour.
That's right. Where's that fee structure in the bill? I'm sorry. And like I said, it's a large bill.
It's not in the bill, but I've got a copy of it here in front of me.
Okay.
But I'll read it out. I'm sorry. I'll read it out.
The fees are actually set, I believe, in state regulations.
By DDS.
Yes, and they're not actually, it's the statutes contain a provision that the department shall regulate fees, and then the actual fees themselves are set in the regulations.
Okay. So I'm reading here that the installation fee for a normal interlock is $75. The lease maintenance fee for 6 months is $60 a month.
Representative Montana, will you give me 1 minute? Can we?
Yes, sir.
Can you want to go ahead and pass that out,
Yeah, I
Mr.
thought
Chairman?
everybody had a copy from,
Go ahead, Representative Montana.
So the installation fee is right. If y'all, does everybody have a copy? I think Representative Holcomb doesn't have one. He's not on the committee. Okay. The lease maintenance fee, this is for a non-indigent, is $360. Calibration fee is right at $90. The uninstallation fee is $75. Now, the installation, I understand that the device is free for these indigent folks.
right.
Okay, so the installation fee here says $0. The uninstall fee is $0. They still have a lease maintenance fee, a calibration fee. So do you know that if in this bill that is required of the manufacturer or the guys that are, because I know our mechanic, we have a fleet of vehicles for our business. You know, and I know he charges right about $125 an hour. And if these installation fees are set here at this price, and we're kind of doing this by either rule and reg or statutory code, I'm really thinking, are we going to shoot ourselves in the foot here as far as people are not, you know, going to be interlock? What I guess what I'm saying is this part of the bill going to be contrary to your actual goal? If interlock providers have a lot of engines coming in and it's taking the money out of the local installers, are they going to be able to install these things?
Well, the installer is getting paid by the manufacturer, probably at the going rate. The manufacturer is the one that takes the loss on it.
Would you be willing to put that in the bill statutorily?
Well, it's already in the rules for DDS. You know, people who have a second offense or more are already involved in this. But you talked about, somebody brought up the probationary license. This also gives the person some benefit with a probationary license. Now you get a limited license, you get caught for DUI. It allows you to travel back and forth to work, back and forth to healthcare, back and forth to school. With this, with the interlock device in there, you have unlimited ability. You can drive just like you could if you had a regular license, because you know, if you're required to blow into the machine, they know you're not intoxicated, so you're free to drive wherever you want to go.
I have another understanding of the way those installation fees work. I do have a deep concern that those installation fees, uninstallation fees, my understanding is those are paid directly to the business that installs these. The mechanic, a lot of these are mechanic shops. A lot of these are mobile and stuff like that. I have a deep concern that, you know, while the device may be free, we're going to be encumbering small business owners, mechanic shops to install these for free by not putting it in statute that the manufacturer needs to pay that going rate. And I don't want to encumber these to, obviously this is a big bill, right? And
Right.
when you start bringing in first DUI folks, that is a very large amount of people. And I wouldn't want to encumber those folks to make those installations without any type of fair, pay on it. Wages are going up, inflation's going crazy. And I want to make sure that those folks are spending 2-3 hours, especially, look, I've got a new truck. It's got a heads up display. I mean, this thing shines and lights up and buttons everywhere on it. There's no telling what's under that dash. And I would just hate for somebody to spend 4, 5, 6 hours to find out, hey, here's my indigent card. I could afford the liquor. I could afford the beer. I could afford the insurance on the car, the SR22 insurance and everything else. But now we're not going to make them pay. And this is part of, it's like you said, it's a self-induced problem. And I think the language of indigency there, I think it's laudable. We want to put as many of these things in there. And I think it's a fair policy goal. I just want to make sure it's not on the backs of these small business owners.
Well, it's already in place, and I'm a little skittish about adding money to it at this juncture. Do we have anybody here from the manufacturer this time? There we go. This lady's from the manufacturer.
Come on. If that's okay, Mr. Chairman, I'd love to hear.
Sure. Let me go ahead and stay there real quick. You can come on up and sit next to the chairman. But I got a quick question, and we got a couple lights flashing too. And this may be for Mr. Crosby, if Chairman Hitchens can answer. Can you just run through how does this practically work when someone is getting this interlock installed? Do they pay these fees to the department, or do they pay them? Can you just run through that for me? I don't know the answer to that, so I need you to.
So typically an individual would be required to have the interlock. They would contact the interlock manufacturer of their choice. There's about 10 that are certified here in Georgia. They would contact that manufacturer, and then I can tell you the process for the company that I'm familiar with. They would call in, and then the manufacturing would work with their contracted service centers, the small businesses in Georgia that would do the install. They would arrange for the install. They would then be responsible for paying for that install with the the service center, either through a PO process or however the contract would state that.
Is that, so do they pay the manufacturer or the installer for those fees?
So if there is an indigency, the manufacturer would cover it. If it was directly, the service center would be paid directly by the person if it was a regular installation without the indigency.
Okay. And is there a cap on that fee? Do you know?
It is under regulations, it's capped at $75. That's a
$75.
That's a Georgia regulation.
So that would be, I think at if I may, Mr. Chairman, I'm just trying to get to the bottom of this and trying to
Sure.
understand this legislation. And thank you for indulging me on that. So I'm trying to understand, I know with my mechanic, that's about half an hour. Is that what y'all feel is a normal amount of time to install a interlock device?
I am not familiar with the actual installation. I will tell you that the average age of the car of our customers is about 13 years. So we're not talking about the new push button heads up display type cars. Typically, the average is about 13 years. I would say that, it would depend on the service center's familiarity with it but probably half an hour to an hour is what it would take.
I think we're outside the bill a bit, but I do want to ask the question, where does the rest of, and this is on another subject, but where do they get do you guys reimburse or something to these companies that are installing if they've gone over?
That would be
$75?
based on whatever is contracted.
Okay.
I'm not familiar with the contracts between manufacturers and the service centers.
I think your line of questioning is, suitable, but it's just that we're outside of this bill. I don't think this bill changes the cost. Does the bill change the cost at all, Chairman Hitchens?
No, driver service does it by regulation, by rule and regulation.
Okay.
Let me reframe the question or give some context, Mr. Chairman. I think the context of my question is if, second and subsequent offenders are a smaller portion of the DUI offender category. I would say multiple offenders probably constitute 30%. And I think you probably have at least a 30% rate of recidivism. So my question would be this: since we're capturing so many more people, right, with this bill, which I think the policy goal is laudable. I don't disagree with the policy goal. I'm just worried that we have these we're taking what is maybe something that a small business owner can afford, right? They can afford to install these things. But when you open it up and you almost triple the amount of people coming in, you've now tripled or more the amount of indigencies coming into that business. So the policy goal is creating a new surge of new customers that these business owners may or may not be able to afford. And I think if we're going to make this big of a change to policy, you have to start considering kind of the tertiary, tidal wave that's happening to all the subsequent people down the line, right? And so I do have some deep concerns here, Mr. Chairman. Now, we'll leave that there, and I do have some more questions on some other topics at the appropriate time.
Yeah, I appreciate that. I get where you're going now. So it's not so much the fee, but the number of folks that are. Can you, Mr. Crosby, can you tell us the number of first-time offenders versus the number of second-time offender DUI?
I don't know that I have a specific number for that. I will note, I think our understanding of it is approximately 75% of folks who are convicted for a first DUI do not reoffend. So it is definitely significantly larger. We are aware that this is, I would note we're talking about this bill specifically applies only to alcohol related DUIs. Folks who are convicted of DUIs that are related solely to drugs or inhalants or something like that would not be covered by these requirements. So we are talking about a subset of all DUI convictions that take place in the state. But I don't know that I can tell you what type of, I understand the question relates to what type of volume addition are we expecting, seems to be the concern.
I got one more before you, Mr. Representative Montan. Thank you for the answer. Chairman Smith.
Yes, thank you for bringing the bill, Colonel. Good to see you again. I'm reminded of what was told to me by one of my former solicitors in Carroll, that when a DA came down to try a DUI case, get a little experience, he went through, and after he was done reviewing the trial manual that they had, he commented that it seemed like it was harder to try DUI cases than it was murder in the state of Georgia. And the solicitor commented and said, well, that's because there's more drunks in the legislature than there are murderers. So with that, a little comedic relief here, but anyhow, there is a concern that I have here with this, and it goes to the reduction of charges. This is an increased fee. You're already looking at 1,900 plus in statutory fees and add-ons when you handle this. I've handled these sort of cases before, and this increased cost. And so I wonder what your thoughts are on the amount of cases we'll see reduced from DUI to reckless driving if we implement this additional requirement on those that are found and plead guilty to a first offense DUI.
If that question was directed to me, sir, I would just note that Pam Bettis is here for the Solicitor General's Association. She is, I believe, prepared to testify online, and I'm getting confirmation of that. So that actually technically did work itself out. I would defer to her for as far as that as a policy consideration. But I would note that Chairman is accurate that DUI cases can be very complicated to prosecute. Just as a nature of, there's a great deal of technical evidence that's involved, even when you don't have a test, because of the nature of field sobriety evaluations and what goes into administering them and interpreting them. So it is and the prosecutors are aware that these things do affect the calculus of how many cases will actually be tried.
Okay. Thank you.
Did you have a follow-up, Representative Montaigne?
Yes, Mr. Chairman. I had in my notes, I kind of had the same thing. So after talking with some folks locally about the bill, I do have concerns. As you know, Georgia has a multiple offender basically pathway, right? And so you have penalties for the first, you have penalties for the second, and you have penalties for the third. I think there is some consideration that needs to be done after talking with folks that are local about the bill. Obviously, it's a big bill, right? So it needs to be, it's like an F and you got to eat it, spoonful at a time here. We did have some question as to, again, I want to get to the actual, we can make policy here in the Georgia General Assembly, but when it gets back home, things don't go the way we ever saw them going. And so one of the questions I had was, if somebody goes, and I think the commentary that I got back was, hey, these charges may be so in the judge's eye, not mine. I'm fine with all of it, right? Outside of the fees, I think we don't need to burden small business owners with those kinds of set fees. I say charge them, hey, let them have it as much, but in the context of this multiple offender status, you have treatment pathways that are built in. You've got things like clinical evaluations. You've got things like intervention and assessments. You've got a lot of different things kind of up and down the line that may get affected if a judge feels that first conviction punishment is too steep. And so he makes it, less safe, or he drops it down to reckless driving. I think there has to be some consideration as to the plea downs. I know that Representative Jesse Peachtree is looking at a piece of legislation to consider the plea downs, and to prevent those on a DUI charge from escaping those mental health pathways. And I think it's something that we are working on this year with our Speaker, Ralston. We need to start considering mental health as part of that pathway. If they dodge these pathways, I'm afraid they're not going to get the treatment they need, right? And we need to make sure that probably plea downs is part of this bill. And that's just the reality. If people plea down these charges from first DUI to other things because they feel like it's too harsh, yet we agree that it's the right kind of punishment, then I'm afraid they're going to miss out on the opportunity for that rehabilitation. And that's a deep concern of mine, right? As somebody who's seen this happen, right, firsthand, who's experienced that loss, I want to make sure that if we do have these punishments, that they're not only getting the punishment, but they're seeking some rehabilitation, whether it's inpatient or outpatient or whatever it may be. I think that is also a policy goal that we should achieve here with this bill. Mr. Chairman, I have other comments. I don't want to waste too much of the committee. I know you got a lot of bills on the calendar today, but you just let me know how much time
Well,
you got.
we got plenty of speakers, Mr. Montan. You'll be able to chime in on those speakers when they
Thank you,
come
Mr.
in. If you
Chairman.
don't mind. Chairman Hitchens, do you have anything else before I move on to these other
Not
speakers?
really, except that, I've seen it in action. They plead down already in many cases. I've even seen one from your home county where they used to plead them down to littering from DUI. So, that's the system. And when we added the reckless driving code and he started pleading them down to reckless driving, I had a talk with the judge, and he wanted to know what the difference was while people were losing their license with reckless driving, and you get 7 points for reckless driving. So then they were accumulating the 15 points in 24 months, which was causing them to lose the license instead of through the DUI. So he asked me the difference, and I said, well, moving hazardous violations are those that as you're driving down the road that could cause an accident. Things like loud muffler, littering, and expired tag are non-hazardous. And so he started changing the DUI plea to littering. So that was many, many years ago. It's not like that there now.
Well, I appreciate that, Mr. Chairman. I'll let you wind it up after we hear all the testimony, if you like. I'm going to move on. We've got the majority of the speakers today are for 439. So I am going to run through these speakers. Before we do that, one quick question, and this will be for Ms. Crosby. On lines 116 through 129, is that just reformatting, or what is that?
Yes, Your Honor, those are primarily technical changes. Those refer to code section refer to mandatorily suspendable offenses, which are listed in code section 40-5-54. Those offenses are things like fleeing and attempting to elude. Those would be racing, suspended registration is in there, and some other serious traffic offenses that by them are not necessarily alcohol related or drug related, but by themselves have been deemed serious enough by this legislature to warrant a mandatory suspension. This is just setting out the provisions of those, and then DUI provisions are handled at separate places in the bill to facilitate the ignition interlock limited device permit being applied to DUIs, but also so that an ignition interlock limited device permit doesn't end up getting ordered to someone who's convicted of straight racing,
Right.
and doesn't have an alcohol issue. And I will just say generally, reference the size of the bill, sir. While it is lengthy, a great deal of it is simply making sure that provisions are harmonized. Our traffic code is very extensive, voluminous. And when you change one provision, when you intend to make the specific policy changes that the chairman has referenced in the bill, there are a lot of places you have to go to make sure that that everything is done across the board.
Okay. All right. Thank you very much.
Yes, sir.
All right. Let me, if you guys want to slide over and let them use the mics, that'd be helpful. We've got the first one, Erica Eckley. Thank you.
Let me- Thank you. My name is Erica Eckley. I'm with the Coalition of Ignition Interlock Manufacturers. I'm going to keep my comments brief and be here for questions if there are some. But I wanted to show you, in talking with people, a lot of people are not familiar with it, what an ignition interlock looks like. In the interest of time, I'm not going to do a full demonstration, but I'd be happy to do that for anybody outside the committee hearing if you'd like to see a full demonstration of it. But all of them operate basically the same way. This is installed inside the car. And then you need to provide a passing breath sample. In Georgia, that would be 0.02 or below. And then once you pass that breath sample, you would be able to start your car. If you have a breath sample above that, then your ignition would not start. It also it does have some provisions, as the chairman said, about providing some random retests. Once you start your car, you do have to provide them. It does not actually slow the car down, but there are provisions that can be put in place to encourage people to pull over if they do not provide a breath sample or do not provide a passing breath sample, but it will not cause any kind of safety issues. There is a time to provide that sample. That's the time period where they're encouraged to pull over to provide that breath sample. So I just wanted to clarify on that. Primarily, I wanted to focus on the fact that ignition interlocks have been highly studied. I have a list of some of the most recent studies that have been done for the committee here, if you'd like. I have full copies of some of these reports. If you want them, I can leave those as well. But I just want to say that ignition interlocks are not a punishment so much as they are a safety measure, and they also work on behavioral modification. The reduction in recidivism for individuals, primarily while these are installed, is very effective. And so in Georgia, I know the increase in deaths in 2020 from impaired driving was increased by 13%. So this is the time and to really put into place provisions to do this, like 34 other states have. I also want to focus on the fact that based on MAD data of all of the manufacturers in Georgia, in 2020, there were over 4,000 stops of individuals who had these installed in their vehicle where their breath alcohol was above the legal limit of 0.08. So these do work and these do stop. That was 4,000 stops of drunk drivers off of the roads in Georgia. So these work, and I would be happy to answer any questions that you guys have.
Representative McLaurin.
Thanks, Mr. Chairman, and thanks for the data and for being here to sort of walk us through some stuff. I mean, my sense on this is that there's no doubting that the technology works to save some lives. And, you know, it ends up being about balance. I mean, we talk a lot about liberty in the building and, you know, what are the trade-offs? And we wouldn't accept a wholesale concession of liberty, just like we wouldn't, you know, prioritize liberty at every other cost, one would hope. And so I guess it's about balance. Couple questions. One is I would appreciate as much clarity as we can possibly get on that clarification you made about auto slowdown or whatever. When I heard that earlier in the committee hearing before I walked in person, that concerned me a lot. Is there any extent whatsoever to which the device takes any control from a driver on the retest?
No, it depends on the state rules, but these can be connected to lights or horns. And so if somebody doesn't take their random retest, the horn can start honking, various things like that to provide incentive for individuals to pull over on their own or to provide notice to people that there might be something going wrong with the car that if there were a police officer or something, they would want to investigate. But it does not stop the car or take over control of the car. It just provides that breath sample and records that breath sample. And then if it's too high, when you first start the car, it will not start the car.
Okay. So, I mean, but that, you know, not to like make light of it, it sounds maybe a little chaotic if, you know, you're driving 80 on the interstate and the horn just sort of blares intermittently. I mean, something like that is what you're saying the signal could be.
If you don't take the random
The
retest,
retest.
which you would have you would have multiple, I don't know it's between 5 and 10 minutes. I don't recall
Okay.
exactly what Georgia's is, but you would have a period of time to take that test. If you choose not to take that test, or if you take a test and it's too high, then those types of things. Those are types of things that typically are handled through the regulatory, through the department that's going to oversee that.
Okay. Thanks for that. I think the only other follow-up I have for now is, have we discussed and I've been in and out of the room, so I apologize. Have we discussed the sort of bagel / Listerine type allegations about the devices, false positives? I mean, what is the word on sort of ordinary life causing you to test positive?
If you want, I would be happy to show you. I have mouthwash in my bag. I can plug this in and show you. Basically, you're gonna, if you just have alcohol in your mouth, it's going to quickly dissipate. And so you can blow a hot blow, and then within about 2 to 2.5 minutes, you'll be below the legal limits. Whereas if you have been ingesting alcohol, your body is going to metabolize it a lot slower. And so you're not going to have that rapid decrease. So if you do happen to forget, you get up in the morning and you brush your teeth and you mouthwash and go straight to your car, you might have a hot blow, but then within 2 minutes, you can blow again and start your car.
So the bread issue too, I know that sounds kind of silly, but in years past, I heard about bagels.
Yeah, there's a lot of myths about it, but
Okay.
I mean, mouthwash will do it, but I don't believe.
Einstein Brothers will not. Okay.
You have mouthwash here?
I do, sir.
You brought it with you.
Yes, sir.
Okay.
And I'd be happy. Well, I mean, I want to put on my best face for you guys, right? I mean, we're kind of close, so.
So there's no other, and the last question would be, there's no other false positive sources that you're aware of besides
Well, I mean,
actual
it
alcohol or
measures alcohol.
alcohol? Okay. Okay. Thank you.
I got one more question.
Oh, sorry.
Representative Montana.
Thank you, Mr. Chairman, and thank you for your presentation. I'm actually interested. I need mouthwash, so it may be a twofer. Let me ask this, and that is, as far as the folks, and I'm going to get down to the kind of small business side. That's my concern. I'm not a lawyer, and I'm on this committee, and I kind of look at things as the layman that just out here trying to earn a dollar for his family. And so, as far as the penalties go, let's talk about the people who are checking. So presumably, let's say you get pulled, you're blowing this thing and it says no, you're traveling down the interstate or whatnot, and it starts to honking and it starts to do whatever it does, right? Lights are flashing and all that other. So you pull over on the side of wherever, 285, or could be, Buchanan Highway out my district, and you pulled over. There's somebody who comes out here and checks this device. Is that correct? That's my understanding. If you needed an emergency, you could have somebody come out and check your device.
There would be manufacturers would have a 24/7 phone line you could call if there's problems. If you have blown hot and you're over the legal limit, the device isn't going to let you start your car if you turn it off when you're on the side of the road. So
Are there services that come out to the vehicles to check those devices?
Uh,
And if they are not over that limit, then they would be unlocked. That's my understanding is that some of these services unlock these devices on the roadside?
I'm not familiar of that particular service, but if there was an emergency, they would make arrangements to help somebody. I'm not sure exactly what that would look
Okay.
like.
It's my understanding that these services are mobile as well,
There are some mobile, yes.
and that they are coming out to the roadside to unlock these devices for motorists who presumably are not under the influence of alcohol. With that level of responsibility, if you're kind of looking at it from this view that you have a technician who may or may not be certified as a mechanic or whatever it may be. He may just be somebody working in an office somewhere, right? I don't know. I don't know what it takes to install these things. But what are the penalties for that person if they unlock it unlawfully? If they, per se, let's say somebody said, hey, look, man, I can't I blew hot. I blew twice. I've had a couple beers, but I can't lose my job. I've got to get to work. And they broker a deal roadside to unlock this thing. What are the penalties for the technician for doing that, for taking that action?
Well, I'm not familiar with Georgia liability, negligence, I mean, there's a lot of legal issues there. As far as this, the technicians would be trained. If one of the manufacturers found out that a technician did something like that, I believe that they would no longer be a technician for the manufacturer.
Do you know how often that happens?
I am not familiar with something like that happening.
I just, again, and this is a long bill, I just want to make sure that we're kind of looking at the I think this bill is a good policy. It's like what we probably need to start getting to. But what I want to make sure of is as we're changing this baseline, this top tier, right? We're saying, hey, you've got, if only 25% reoffend of all first offenders, you're talking about a 300% increase in the amount of these, right? And so if we're going to add 300% more interlock devices, presumably in the roads of Georgia, I want to make sure that there's not going to be technicians that are in, Powder County, Georgia, that are unlocking these things for a cash price. And so we kind of have to start thinking these things through in each and every scenario, because it's becoming a bigger, right? We've got a small silo that it's in, and the grain bin's about to get full and start overflowing, right? So we got to start thinking about all these scenarios and how do we handle that? To my knowledge, there isn't a penalty for these folks. And if there is, we need to start talking about that. And that conversation probably needs to be in this bill, right? Is how do we handle those folks? Because what we don't want, I think, in my opinion, and I'll just posit this for the committee, is that we treat them as lightly as we would an emissions, technician who could presumably do safety inspections and or emissions inspections. We want to raise that bar and say, hey, if you're allowing a drunk driver back on the road with these systems, that they need to have almost equal punishment to the actual offender. Because if the goal is to not have a DUI offender on the roadways while they're intoxicated, then we can't also have people allowing them to do it.
So all the technicians and service centers are approved through the Department of Driver Services here in Georgia. So there is oversight of these. They have to meet requirements. They do criminal background checks. The department has to approve all of them. It's a lengthy process. So there is oversight on that. If there's specifics getting to that granular level, a lot of times that can be handled through the regulatory process, and Driver Services does have regulations on this. I think a lot of these could be handled through that regulatory process and really providing those granular details of how the program will be run.
One thing I noticed, Mr. Chairman, if I may, just one last thing for the lady who's presenting today. Thank you so much. After doing a review of the DDS website, there is no single technician application for these. There's only a program application. So presumably an owner of a business could qualify under the rules and regs and provisions, and that's through statute, but the technicians would not. They would fall under that same license. My fear is that we have technicians that may or may not be being licensed and fall under, that may be stretching their authority of the program that they're working under.
So if you were the owner of a service center and it was your license, would you permit a technician who did that type of process to continue to work for you?
So I see what you're saying. I think that is a ideal policy kind of discussion when you say, would you allow them to do it? I think most business owners like myself would tell you, no, we wouldn't let them. But that doesn't mean that it doesn't happen, right? And if our policy goes to keep drunk drivers off the road, we need to make sure that they have the accountability that's needed to keep them off the road, right, as well. And if that means losing individual licenses without punishing an entire business for the actions of one person, I think that should be a policy goal that's in this bill.
Thank you. Thank you, Mr. Representative Monahan.
Thank you.
I got one question online. Would you unmute yourself, Representative Grabbley?
Thank you, Mr. Chairman. Let me ask the the author of the bill and the interlock representative. Has this bill proven in other states to save lives?
All offenders are in 34 states. It has saved lives. There's research for many of the states, New Mexico. I think Chairman Hitchin had the full list of the reductions. In West Virginia, there was a reduction of 60%. Drunk drivers creating traffic fatalities. Louisiana 41%, Delaware 40%, Vermont 40%, Arizona 34%, Kansas 32%, Oklahoma 29%, Arkansas 25%, and Mississippi 19%.
Of percentages, could you, and that percentage is representative of what?
Of those states passing all offender laws similar to what this bill is.
So what we have here is a situation where I think we have in the state of Georgia looked at a variety. It's unfortunate that we have to, but we have looked at a variety of policy measures, mechanisms, ideas. How do we, number one, try to stop people from driving drunk? But yet, the most important thing, how do we keep people from killing other people because they're driving drunk? Right? So, and the reason I say that is my wife and I live in a little subdivision in Paulding County. Representative Montana and I represent the same area. One morning, our neighbor, he got up and left for work every morning at 4 a.m. And his children and my children, right about the same age. And I was at the Capitol. Matter of fact, this was about 4 to 5 years ago. And on his way to work, he was going down a little highway called Highway 92. And he would get up every morning, go to work and get off by 4 or 5 o'clock in the afternoon. I'd see him out in his yard playing with his kids. They'd walk around the neighborhood. My kids would stop and play with them. His wife would stop and speak with my wife. And, kind of this is what neighbors do. Until one morning, he was headed to work. No one was on the roads. And out of nowhere was T-boned by a drunk driver. Someone who had repeat offenses. Someone that had probably been ordered or suspended for whatever reason this individual was driving. It killed him instantly. So him and his wife were high school sweethearts that had grown up in our community. The other night, I was reminiscing about the fact when I was talking to Chairman Hitchens about this bill. My wife and children follow that same road. Sometimes we're coming home from ball practice. My daughter is going to be a driver in the next year. God forbid the life of my wife or the life of my child be taken by someone who was able to get in a car and crank it with alcohol on their breath. Now, if this device prevents someone or requires someone to breathe into this device, maybe it was my wife or my child that they now aren't going to hit and change my life forever. So we can work out the details, but when I look at this bill, and the reason I'm a co-sponsor of this bill is because I think back to my neighbor and how my children grew up with a father, because I wasn't on the road at 4 a.m., 92, which is right by my house, and he was. So you have one house on my street whose kids grew up without a dad. And then you have my house right next to it. But because I didn't have to be at work at 4 a.m., my kids grew up with a dad. Now, we can argue everything about it, but at the end of the day, this comes down to whether or not an individual can crank a car, put it on a road that's driven by the public. That's not a right, with alcohol or under the influence. And with kids getting to driving age, that makes me highly, highly fearful. Thank you, Mr. Chairman.
Thank you, Representative Gravely. One question that came in my mind, and Mr. Crosby may be the one to answer this, is as I read these provisions in here, this is allowing for, it's a may, I mean, it's not, the offender may apply for an interlock. Is that correct throughout the whole bill?
Yes, sir.
So this is so if it's your first offense and you want to get, you want to get to driving quicker, then you may apply for this interlock. Is that correct?
Yes, sir.
Go over there.
Everybody hear me?
No, grab that.
Yes, just to be extremely hyper technical about this, the interlock requirement is not actually necessarily going to be a condition of a convicted DUI driver's sentence. If you'll note at the bill, the provisions that amend code sections 40-6-391 more strongly encourage it being made as a condition of probation than it was before, because it's specifically listed now. But basically what happens is the driver's privilege to drive will be suspended as a result of a DUI conviction by operation of law. And then as a condition for reinstatement, the driver then has to spend a period of time. Currently, it's just for a second and 5 with an ignition interlock device. Under this bill, as a condition of being reinstated fully, they have to spend a period of time based on their number of prior offenses with an interlock device permit. Driver is not required to do that, but they won't get reinstated until they've spent X amount of time on the interlock permit.
That's for the second.
That currently exists for the second. That
Right.
rule will exist for all DUIs should this bill pass with those provisions in their current form. The driver basically.
So slow down there for me.
Sorry.
So currently, after your second, you're required to get the interlock to get your license reinstated. Is that correct?
Yes, sir.
All right. And this bill, you're saying that after the first, then you're required to get the interlock to get your.
Yes, sir. It works under the same provisions, less time spent under suspension, less time spent on the interlock permit, but
To get them back early,
yes.
to get your license back early.
Yes. And actually, if you do not apply if you do not spend time on the interlock device permit as required, you won't get your privilege to drive back, as I understand the bill.
After the first one.
Yes.
Okay. Thank you, Mrs. Eckley.
Representative Bird online asking us, someone else blowing this machine. So how does that achieve anything?
The question asked online is by Representative Byrd is, can someone else blow in this machine? If so, how does that achieve anything?
So somebody can blow in this machine. In a lot of states, they have moved to a more sophisticated model that requires a camera. Georgia does not currently have that. And so that is what also the purpose of the random retest is. If you have somebody else blow into it to start the vehicle, you would have to provide a retest periodically while you're driving to ensure that there isn't that alcohol. And that's when there could be light horns honking if they don't provide that, or if it's at a high level.
Okay. Chairman Ballinger has a question online. Chairman Ballinger, would you unmute yourself, please?
Yep. Thank you, Mr. Chairman. I appreciate the opportunity. What are the rates of recidivism in states that have ignition interlock on a first offense versus those that do not?
Typically, the rate of recidivism, while it's installed, is at least 67%, I think is what the most recent research shows. There are additional ways that states are investigating to improve that further on. And that would include things like compliance-based removal, ensuring somebody has not had any violations during a period of time during their provision, but that is not included in this current bill.
Okay, now what I'm asking is if a DUI driver, you have driver A and they get an ignition interlock device. It's their first offense. They get an ignition interlock device. They complete the program. They're off 5 years later. Driver B got a DUI, didn't have an ignition interlock device, but went through the usual DUI punishments that we have in Georgia 5 years later. What is the likelihood of driver A versus driver B actually, having another DUI? Is there any change with the use of the interlock device?
There is a change in it. It is basically, it's a behavioral modification. You are learning that you cannot start your car if you've been drinking alcohol. And so the period of 6 months is a period of time where that is reinforced daily every time you go out and start your car. I don't have specific statistics in front of me of what the 5-year recidivism rate is, but typically it's about at least 67% for people who have them while they're installed.
You don't know
Thank
this,
you.
correct?
I do not have those numbers.
Okay.
I got a light flashing. I'm gonna give one more question and then we're gonna move on to the next witness.
Okay.
Can I
Thank-
respond for just a second?
Sure. Yes, sir.
There are two things that have come up since I was up here, but number one, I apologize for that slowing down. I got that from somebody who actually had a interlock device in his vehicle about 10 days ago, and he told me that. He hadn't been drinking at the time, but that was something I was just told. The other thing is when Representative Monahan was talking about, is there any penalty for anybody that blows in or alters the device in any way? It's on line 941 under 42.8-118 is unlawful for any person whose driving privileges are restricted pursuant to subsection to request or solicit any other person to blow into an ignition interlock device or to start a motor vehicle equipped with the device for the purpose of providing the person so restricted with an operable motor vehicle. It is unlawful for any person to blow into an ignition interlock device or to start a motor vehicle equipped with a device for the purpose of providing an operable motor vehicle to a person whose driving privilege is restricted pursuant to section A or B of code 42.811. It is unlawful to tamper with or circumvent the operation of an ignition interlock device. Any person violating any provision of this code shall be guilty of a misdemeanor.
Thank you. Representative Montahan.
Thank you, Mr. Chairman. Mr. Chairman, thank you for that. I see that now. Would you be willing to accept an amendment on line 952 to change that to felony?
I'm sorry, but I just don't know that it rises to that level. I think, I'd like to see this bill passed. I think when we add some of these provisions, I think it would hinder, that's a pretty serious charge. A felony, 1 to 5.
I agree. I think it's putting these folks back on the road, though. I think, in
Well,
my opinion, I'm trying to get it to where, the penalties are very similar for someone who would put these people back on the road knowingly that they could kill somebody. And so I think as part of this kind of conversation is these people are basically allowing them to do it. And I think, that would be an amendment that I'd want to see in the bill to really start punishing these people that are maybe doing this for cash. I mean, if you imagine, I think, and this is where my mind goes. Hey, I got to get to work. If I give you $500, will you unlock this thing? Then they go kill somebody. And so I'm very
Representative
afraid.
Martin, Montan, excuse me, when you want to make that amendment, when it's time's appropriate for amendment, go ahead and make the amendment. And
Thank you, Mr.
if that's
Chairman.
what you want to do with it. We'll see what the will of the
And all I
committee
would
is.
say is this is a misdemeanor offense and we're gonna make it a felony to alter. So.
All right, I'm going to come right back to you, Representative. Will you be quick and concise? Because we've got one of 11 on 439.
Understood. Thank you, Mr. Chairman. And to the chairman and author, we didn't get a chance to talk about this earlier, but quickly, I think my biggest lingering concern in terms of the structure of this is there's a starting on line 415 or 414, really. There's a shall revoke mandatory revocation of a limited driving permit or IAD limited driving permit for any violation of Chapter 6, not just moving violations.
Yeah.
So this is lines 419 and 420 is the meat of it. Basically, there's a mandatory revocation of the permit for violating any provision of Chapter 6 of the title, which my understanding is that that would encompass more than just moving violations. And I wonder if there's some policy reason to do that.
No, and that, I don't, to be perfectly honest, I don't know how that got in there. If you want to make an amendment to take that out, it certainly, I'm not sure it's really germane to what we're talking about here.
Sure will. I can at least limit it to the moving violations
Right.
if that works for everybody. Okay, thanks.
Thank you. I'm going to take ease for about 5 minutes. I've got to go take a phone call real quick. Give me 5 minutes.
Thank you. You did a good job.
Thank you very much. So it's my things, when I saw it, I was like, I was aiming for
On track here. Thank you for the brief pause. All right, I'm going to call up the second witness, Gilbert Crosby. Did you have any additional testimony, Mr. Crosby? Let me move on down to the next one. Mr. Crosby, did you want to give additional testimony? We got you on for next.
No, sir. I just wanted to make sure that I was registered. I'm here for technical questions as they come up.
Very good.
Ms. Bettis, when you reach her, we'll speak to policy issues for the solicitors.
Thank you very much. All right. I've got Edward Lindsay. That's it. Yes.
Thank you. Thank you, Mr. Chairman. My name is Edward Lindsay. I'm with the law firm of Denton's, and we represent the coalition of ignition interlock manufacturers as who are working closely with MAD and other and responsibility.org in favor of this bill. All I want to do today is, quite frankly, very quickly thank all the folks who worked very hard on this bill over the past year. We've met with countless individuals and organizations. I do think they need to be acknowledged to this committee in terms of the hard work that's been put into it. We've met literally for hours in multiple meetings and multiple emails and communications back and forth, including folks like the Georgia Association of Criminal Defense Lawyers, the Department of Driver Services, prosecutors who in particular, and you've already met Gibb, as well as Pam Bettis, who will testify, who spent an enormous amount of time. We've met with law enforcement, we've met with legislators. We've worked with the Georgia Association of Risk Reduction Defense DUI schools people as well. This bill is a tool in the toolbox to move things forward. There is no absolute bill that will absolutely end, unfortunately, but this will move things in the right direction. The statistics that you will see on the forms that we handed out show that this has a very positive impact. It has a positive impact in the other 34 states. A lot of the concerns that or the questions that have been raised, if this was the first state to ever do it, you'd go, well, is it really going to be effective? You know that it will. Also, we've also worked with indigent. The allowance for folks to get it at a reduced cost is something that's been done in other states as well. That has not had led to a reduction in the number of service providers, but actually an increase because of the expansion to the first offenders. Representative Monahan, you were concerned about who bears the cost for the indigent underneath the rules and the contracts between the manufacturers and the service provider. It's the manufacturers who bear the cost for the reduction in the services, rather the reduction in the cost because of DUI. I've sat on this committee for a long time, for 10 years. And I will leave you with the great advice that that gentleman right up there gave me one time when I was working on a bill. Do not let the pursuit of the perfect defeat the good. And the fact of the matter is, this is a very good bill that will make the roads in the state safer. I say that not only as a lobbyist for these organizations, but as a victim of DUI. You see a slight dent in my forehead. When I was 2 years old, someone crossed the center line and hit my mother head on, who was driving drunk. So I'm a great believer in whatever we can do to make the roads safer for your children and my children, for our families, and for the rest of the people of Georgia. That's all I really have. Happy to answer any questions, other than also thank, obviously, Chairman Hitchens, who has been with me for the past year as we worked through all these various organizations and gotten the input. No one has gotten everything except for maybe DDS, but just about everyone, I think, could fairly say that issues that they thought were concerned, a lot of those issues were addressed. There's still always a few more. Happy to sort of work with continue to work with the committee on those things.
Thank you, Mr. Lindsay. You
Thank you.
got two questions.
Sure.
Representative Montan.
Thank you, Mr. Chairman. Ms. Lindsay, thank you so much
Sure.
for your contributions to the state over the decade of service that you have given it. And also thank you for the representation of these fine groups. A question, and I know we don't want to let the perfect get in the way of the good. I agree. Would you be amenable to moving the bill if it did not have an indigent waiver in it?
I think if whatever it will take to make it easier for some people who are indigent to get it, as opposed to simply choose not to drive for 6 months and probably then wait 6 months and start drinking. I think anything that will encourage folks to get it is a good thing. Since the manufacturers are willing to absorb the cost. And so for that reason, I think that we would prefer that the indigent language be put in there. We did choose, as you will see, if you've got the summary, you can see the lines that will show exactly. We did choose objective standards, meaning that the individual is already receiving some kind of aid to show their indigency. So a lot of the ambiguity that comes in is taken care of. But anything that I believe that my clients have told me that by putting indigency issues in there and making it cheaper for someone who is poor, who to encourage them to go down this path as opposed to simply sitting out for 6 months would be a good thing. So we would prefer that it be in there.
Further question, Mr. Chairman. The 70, I know you said that the manufacturer bears cost of the installation and they're here today and represented. Would you be amenable to changing that to and uncapping it from $75 to protect those small businesses in a time of great inflation?
Well, I would say that I would sort of leave that to DDS because that's set by regs. And so I don't want to step on to DDS because I've worked real closely with them on that. I don't know if anyone here is from DDS.
I think it's policymakers here.
Yeah.
On this
Well, no,
side of the
I
table,
hear what you're saying.
right?
Hopefully you understand what I'm saying. Is
Sure.
that I don't want to step on they're the ones who've set the rates in terms of what can be charged and what. So I will simply ask that you sort of consult with DDS as to what was its rationale for setting that at $75.
Well, thank you very much. And we are tasked with a great responsibility
understand.
here, and that is, and I love my partners at DDS. But sometimes when you put, government barriers in between small business and, these others, it can really affect them in a way with a great lead time before it gets rectified. And I just want to make sure that when I saddle again, we're talking about a 300% increase. I really have deep concerns that we're going to be saddling small businesses with a lot of indigent waivers.
Understand. But I will say this is that when you move from second offense to first offense throughout the rest of the country, the number of providers does increase. So it obviously shows that they do feel like they can continue to compete. Like I said, I'm taking no position on that issue.
Yes, sir. Thank
And
you.
I understand where you're coming from. I just want, like I said, since DDS did work with us, I'm not going to take a position on it. I hope you understand.
Thank you, sir. Appreciate you.
Thank you. And like I said, it's a tool in the toolbox, just like when we moved to require anyone charged with a DUI to go to DUI schools. That was a positive move in the right direction. And this will be a positive move in the right direction as well, Mr. Chairman.
Representative McLaurin.
Thank you, Mr. Chairman. I just wanted to say, the only advice I ever got from my predecessor was, I don't know what to tell you, kid. You just got to knock a lot of doors. That's basically the way to do it. But
That's how I got elected too.
there it is, right? But to your point, I appreciate the work that has gone into this over several years. When it first came to the committee, there was a lot of, more heartburn about it. And I appreciate just the willingness to dig in. It's made it, I think, put it in a much better posture than previously I approached the bill. So my thanks for that.
Thank you. And the point that you raised a while ago, we would be in favor of that amendment. Thank you, Mr. Chairman.
Thank you. Up next, we have Jill Travis from GATCO.
Good morning, Mr. Chairman, members of the committee. Thank you for having me today. My name is Jill Travis. I'm the Executive Director of the Georgia Association of Criminal Defense Lawyers. I know this gentleman over here is tired of hearing my voice and my comments on this, but I so appreciate how much he and his team have listened to what we've had to say about this bill. And I hope that it's substantially improved the nature of the bill. One of the things that was added in the last go round, which we were most appreciative of, was that at least the industry would give back some money to the state for installing these devices. That's found on page 28 at line 719, $30. We had actually asked for that figure to be higher. The DUI schools give back to the state. They get a business from the state as well. They give back $30 for each person that goes through a DUI school. That cost is $300 some dollars. So if this is going to be at least $600, it seems like maybe $60 would be more fair to consider for this proposal. With respect to, I think does this concept help public safety, and how is it going to work, is the $64,000 question. As Mr. Crosby explained to you, that this IID on a first DUI doesn't necessarily have to come on right at conviction, but it does have to be something that's a check mark before somebody can get a driver's license. And I think the visual that all of us have is somebody goes out, they get a DUI, and they realize, oh my gosh, either they realize, oh my gosh, how did that happen? I shouldn't be doing this. And they sometimes go and get an ignition interlock device right then and there. And one would think that that's the most critical time, because you're curbing behavior right at that initial stage. And that is something that the person can do on their own. It can be done as a condition of bond. And I think that in our minds, we can see that the time and space, it's just like when you're punishing your child, you want that action. You can't take it a year later and expect it to have the same effect. But yet that's how this can operate, because it is not done in that manner. Right now, at the time of conviction, the judge could say, I'd like you to have an ignition interlock device on your car as part of your condition of probation. There's nothing stopping that from happening now. So the issue really is this going to be something that's going to be helpful to society? And is it going to deal with the addiction problem that the person most likely has that's suffering from this? And I think the jury is out on that. Our organization does not think that requiring an ignition interlock device as part of a first conviction should be as part of the law. However, we have worked tirelessly with the various stakeholders in this to try to improve the bill. I'm going to ask you to consider a few specifics that we have concerns about, and make a few more comments. One, thank you, Representative McLaurin, for noticing the issue on page 17 with regard to the moving violations. The way this bill, if you bring your attention to lines 420 to 422, the way the bill is currently drafted, if you were in a situation where you just didn't have proof of insurance on you, which is a non-moving violation, that would be caught up in this. You'll notice that line 418, movement of vehicles, was actually in the original language of the statute. And I think it just didn't get moved down when the bill was being chopped up. So if line 420 could read, chapter 6 of this title involving the movement of vehicles, semicolon, we'd appreciate that change. Turning your attention to
Restate that.
line 420 at page 17, after the word title, if you could insert the words involving the movement of vehicles. The other change that I'd ask you to consider, I'd ask the committee to consider, is on page 8. Let me give you a little bit of background. Do y'all remember Shaw Blackman's bill that dealt with driver's licenses for people that were convicted of DUI drugs? So it passed, and it kind of left a hole in the law, and it's exacerbated by this piece of legislation, in that the way this legislation reads is having the IID on the car has to do with an alcohol related, because you all know you're not going to put an IID on somebody that's got a drug DUI. But in our minds, it is not abundantly clear that the DUI drug person can get an IID, and I'm sorry, can get a limited driving permit. And we think that that was the spirit of Chairman Blackman's bill. It is actually how the department is operating, but it is actually not the law. And we would like to make it clear within this bill that it is the law. So turning your attention to page 8 in the list, this is in 40-5-64. It's the list of code sections that allow you to get limited driving permits. Sorry, there's too many alphabet involved in this bill. We would ask that a new division 4 be added. So in other words, at line 179, if you made that division 4 a 5 and division 5 a 6, and you added just the words code section 40-5-75 as a new division 4, that would close the loop and make it clear that limited driving permit is allowed for the drug DUI. And I will say that I have discussed that proposed amendment with legislative counsel, not Ms. Carter, Ms. Dolday, and with the department, who indicated that that hole does exist and continues to exist now. I know that I'm going to change subjects. I'm going to talk about the issue of having the ability for somebody who can't afford to have these devices put on their car, and how the legislature is going to deal with this issue. We do think it is important that somebody has access to these kinds of devices, even when they aren't, even when they are not of means. And while we can imagine people of means and the descriptions that have been used here of, going out to the bar and paying however much money for whatever drinks, you could also get a DUI for driving your friend's car because you don't have a car. So it's not everybody that's, wealthy or of means that has an ignition interlock or that gets a DUI. And when you get a DUI, a first DUI, there's a lot of money punishment that's involved. And I guess the theory is that money is going to change our behavior, because it does obviously impact us in many ways when we have fewer dollars to spend. But a first-time DUI is quite an expensive a problem to have. In addition to the fines, which are doubled, if you get the minimum fine of 300, it's going to be doubled by the time you add on the surcharges. Then you've got the schools you've got to attend. You have to get counseling. Hopefully, if you have a problem, they identify the problem. You're going to have more counseling. That's going to cost more money. And now we're adding this potential on. The one of the things that's of concern to us is on page 34. Make sure I'm giving the right line numbers. Yes, on page 34 at lines 864 and 868, the consideration is of the household income, not just the person's income. And while sometimes one spouse may make a lot more money than another spouse, the consideration of household income is something that we think that should not be part of the bill. If you look at what we consider for somebody getting a public defender, we do look at assets, But we don't look at household income. And so we would ask, or household income be removed on lines 864 and 868. I do think that there is potentially constitutional issues in parts of this bill.
Jill,
Yes, sir.
what are you proposing?
Just to take
added?
those words out.
Take them out entirely?
Yes, sir. There is language, let me direct you, sir. At, I believe it's on page 33. Let me get to it. If you look at page 33 at lines 858 to 861, we talk about that in determining hardship, we consider the person's financial obligations, including obligations to dependents. That was language that Gactel asked to be added, and it was added, and we do appreciate that. So we do look at their financial obligations. You know, maybe the person is supporting another, either has dependents or has alimony or whatever is the nature, but looking at other people's income in the household, we don't think is fair in this circumstance. The issue of requiring a private industry to finance somebody they can't afford this is truly an issue that's of constitutional magnitude and impairment of contracts, taking of property. And then you have to say, so a poor person cannot get this. So why are we making it required on all people? I'm going to leave you just with a lot more questions than answers, but we'll say that I think that's something else you should consider. The fee language in the bill was substantially in terms of what the person might pay or what the company may have to pay for installation and deinstallation fees. And I'm sorry, let me back up 1 second to say, it's my understanding that the industry is okay and is doing these services in other states. And so probably the industry is the one that would be raising the constitutional challenge more so than the individual. I don't know how that will play out. I think that the balance of the changes that we've asked for, that we felt like we could get anywhere with, have been made. That's not to say that there haven't been other issues, and I'm not going to rehash those today. That's it, sir.
All right, you've got a couple flashing lights. Representative Montahan.
Thank you, Mr. Chairman. Go back to, I think it was, you're talking about the 40-5-75, is that right?
Yes.
What line was that again? I'm sorry, I've looked at. Trying to find it here.
It would be adding, it's on page 8,
Page
between lines 178 and 179. Imagine putting a little caret in and inserting code section -40-5-75. And the reason why we're asking that change to be made is that's where we allow for the limited driving permits for DUI drugs. If we could go back in time and perfect Chairman Blackman's bill, that change would have been made at that time. It's just, we didn't. And it's exacerbated by the fact that now we're distinguishing alcohol DUI versus drug DUI.
So I'm just trying to understand. So right now, if you had a DUI drug for cocaine or, and presumably I'm walking to the mechanics because I'm not an attorney. So I try to understand these things from either the criminal's point of view or the public's point of view. So if somebody gets, under the influence of cocaine or something like that, and they get a blood draw at a hospital, it shows the presence of cocaine metabolites or whatever it may be in their blood, then at that point, under today, they will not be able to get a limited driving permit under the ALS, the administrative side of things. Is that right? Is that where this comes into place, or is it later in the proceedings?
I believe it is later in the proceedings. I don't believe it's at the ALS stage.
Okay, so they're still able to get a limited driving permit,
So-
and I think that's been 5 days at the ALS hearing, right? So
I'm
this
just-
is post conviction.
That's my understanding. I have to tell you, this is where I'd phone a friend, and we've tried to get some practitioners online. I don't know if we were able to get them on. My understanding is it's at, and also I think Mr. Crosby would also be able to speak to it, that I believe it is at conviction, after conviction, that they get the limited driving permit. I'm not exactly sure on the stage of the limited driving permit, but my friend over here is shaking his head. I don't think we're talking at the ALS stage. I think we're talking conviction. And limited driving permit does limit your driving
Right.
as to the where.
Well, so I guess the policy question is that a loophole or a feature? Right. I don't know that it wasn't. I want to say I had that understanding when we passed that legislation back then, that upon conviction, they would lose their license without a way to get it back. And because of how, I mean, obviously cocaine or another type of narcotic in your system when driving, that's a pretty big problem. I think the issue we're trying to solve with Representative Blackman's, but Chairman Blackman's bill, was those that were taking prescription drugs and under the influence. And so I guess my question is this, or rather my statement is this, and I just posit this again for the committee, is that these folks who get a DUI, let's just clarify some things, are already able to get a limited driving permit to drive before conviction or pre-trial, right? They're already able to go to the ALS hearing. They got a DUI for either drugs or alcohol, and they're driving up to the point of their conviction. So there is a inherent risk that the public is taking, right, during that period. And so, especially now with COVID and the backlog, you've got DUI offenders that are driving without any type of ignition interlock or any type of treatment or whatever it may be for that period of time. It could be a year and a half, right? It could be a very long time. And then post conviction, right now, I think as a feature, not as a bug, as they say, right? They would not be able to get that license. I think that the policy goal here is that driving, drunk obviously needs to be punished in a way that is memorable and changes and modifies behavior. And so I think if the goal is to make sure that pre-conviction, that we are allowing them to drive until they have their day in court, which I think is fair, then that's one thing. But post-conviction, I think we need to separate that out for the members here to understand that you're making a case for, post-conviction, leniencies. And I think for DUI drugs, that may not be something that this committee wants to move forward with. I just want to posit that with the committee, and I thank you for all your time.
Certainly, that obviously the presumption of innocence carries us till we get to the point of conviction.
That's right.
And the and post conviction is where the amendment that I suggest it clarifies the process. And I realize that is a policy decision, but I think it's a policy that this body has already made. They just didn't get the football all the way through the goalpost.
Thank you, Jill. I appreciate you. Next up, we have, excuse me, you got a question online. Mandy Ballinger, or Chairman Ballinger, excuse me.
Thank you, Mr. Chairman. And the question is actually for Jill. I know in a lot of criminal offenses, including DUI, defendants are able to work off if they can't afford something, they can't afford a fine. If they can't afford something, they are able to work that off through community service, usually at a $10 an hour, fairly low rate, but they can, in lieu of a fine, do community service. How would that work in this situation? If I couldn't afford the $75 a month, are there any avenues for me to be able to work it off, so to speak?
No, the and Chairman Bellinger, that's a very good point. Actually, it's 42-8-102 subsections D and E that relate to how you convert a fine into community service when somebody is unable to pay those fees. That was a suggestion that we had made at some point, that we marry those same standards here so that when a judge is determining indigency, they had the same standards. It was thought that the language that was here was in this bill was preferred by the author and the stakeholders. But in this instance, the only way to convert, the only sort of conversion from paying the full amount is the concession in the bill says that the interlock provider will install and deinstall the device for free. They will not charge a security deposit, and the monthly fees will be cut in half. That's the concession that's being made. And from my research, there are other fees that are involved in these. There's lockout fees, there's mileage fees. But that was, as far as this bill is written, that's all of the concessions that are being made. And then of course the department regulates the fees that can be charged by the ignition interlock providers. And I'll contrast that to DUI schools. The legislature determined what the fees should be for DUI schools. So we know what it's going to be. In this situation, we're leaving it to the department and the regulation of the department. So there is still some oversight, but it's not codified.
Okay, so but there is no way of me working and doing something else rather than having to pay the fee. That's correct. Am I correct in saying that?
Yes, ma'am.
Okay, thank you. Miss you.
You're welcome.
Thank you, Chairman Ballinger. Thank
Miss you too.
Thank you, Jim. Next up, we have Aaron Gershon. Yeah, Gershon.
She was my phone a friend.
Okay, all right, so we've got next Rick Burt, 439 with SADD.
Thank you, Mr. Chairman and members of the committee for your time today. I will be brief because you have already heard an array of testimony from a variety of witnesses. They can speak to all the technical elements of this. I work for and represent SAD, Students Against Destructive Decisions. We've been working in this space for 4 decades, and across the great state of Georgia, we have over 18,000 members that are joining us in supporting this measure, and so appreciate the chairman bringing this legislation forward. I think a lot of what this committee deals with lacks a narrative. In this case, there's a clear storyline as to why this bill would benefit the citizens of Georgia. You've heard the story in numbers. You've heard the stories in people who have been impacted. And this bill does nothing more than modernize the state's impaired driving laws to meet the needs of the citizens of Georgia and to keep the roadways safe. I had a chance to chat with several of our student members about this measure, and I met with Michael, who is a 17-year-old in Waynesboro, Georgia. And he said to me something that I think that I would ask this committee to consider. Why would my representatives not put every tool in the tool chest to keep myself and my family safe? I think it was well said that this bill could always be nitpicked and picked apart. The question was asked, well, isn't DUI already an expensive enough measure? I would say that costing one life, one Georgian's life, is far too high a cost. So while there are numerous elements that we could pick apart today, I'm here to encourage you on behalf of the current leaders of Georgia, your future voters, the future motorists of Georgia, and the citizens of this great state to act swiftly to advance this measure. Because while we have spent 2 hours here today debating this measure, people have lost their lives, and this body has the ability to change that. So with that, I'll certainly yield the rest of my time. Appreciate you, Mr. Chairman, for your opportunity to speak, and can answer any questions that you might have on behalf of SAD students.
Thank you. We've got Representative McLaurin.
Thanks, Mr. Chairman. I just wanted to torture Mr. Burt briefly and let him know that I think there are actually lots of other issues in this committee that have a narrative.
Sure.
Quite a few actually. But thank you for your testimony today, and want to also applaud that you're engaged from a student perspective as well, not just the people who are obviously impacted by these issues, but this is truly an issue that affects everybody. So thank you.
Well said, sir. Thank you.
Representative Sines. Representative Saints.
I apologize, waive.
All right, thank you, Mr. Burt. Next, we have Brandy Axdahl with responsibility.
Responsibility.org.
Oh, responsibility. I thought it was a clever play on the word. Oh,
Thank you. Thank you, Mr. Chairman. Thank you, Mr. Chairman and distinguished members of the committee. I am Brandy Axdahl. I'm the Senior Vice President of Responsibility.org. We are a nonprofit that's been in existence for more than 30 years and is funded by the world's leading distillers. Prior to my position here at Responsibility.org, I worked at the MAD National Office for 10 years as well. In that role, my first boss was a lawyer from Savannah, Georgia, whose daughter was killed in a wrong way crash with a driver at a high BAC level. And that has always stayed with me. Last week, the United States Department of Transportation released their 2020 traffic fatality statistics. Traffic deaths increased almost 7% last year, and it's the highest fatality rate that the nation has seen since 2007. Drunk driving deaths increased 14%. In 1 year, our progress has been knocked back more than a decade, and the 2021 statistics are predicted to be even worse. This is at a time when miles traveled were way down because of COVID. We're going the wrong direction on this issue. Ignition interlocks stop a person from driving drunk while they're on the car. The way the system should work, and today I'm here asking you to pass this bill, but the different people who are testifying for this bill will also be working with judges and prosecutors and driver services to make sure that people who are driving drunk and have an interlock on their car get a screening and an assessment for substance use disorders and substance abuse disorders and mental health disorders. That's how the system should work. But make no mistake, the ignition interlock is the most important piece of that system because it stops somebody from driving drunk and it helps somebody on a first offense not to become a repeat offender, as many of them do. Lastly, I'll just talk about New York for a moment. New York was one of the early adopters of this law. It's named Leandra's Law, and it's named that because so many children, and one child in New York was killed riding with a drunk driver. Many children are killed that way. And one of the calls I used to take at the MAD National Office that was so devastating were people who were single parents who had to let their children go in the car with a drunk ex-spouse. And there was nothing they could do about it. This type of law stops that from happening. I hope you will pass this bill. It's so important to take this step forward at a time when our nation has a traffic safety crisis on our roads. I'm happy to take any questions, and thank you for your time.
Thank you for your testimony. I appreciate you coming on. It doesn't look like we have any questions online or in person, so I appreciate you. Next up would be Pam Bettis, Henry County Solicitor.
Good morning. My name is Pam Bettis, and I am from the Henry County Solicitor's Office. I did want to talk about a couple areas that were brought up earlier. One is the section starting on line 418 that Jill talked about. If I could direct your attention to that section, page 17, line 418. And Jill talked about just taking the strike away and leaving in the restriction, any movement of a vehicle. So a person would not lose their permit as long as they did not commit a violation that was a movement of the vehicle. And as a solicitor, and I think I can speak on behalf of the other solicitors, we have a real problem with that, because now a person could, have an open container, which is under the 40-6-253, who's driving around now with an ignition interlock permit, has an open container, but that is not considered a moving violation. And I don't think that that's what this committee or our legislature would intend. We have already agreed to remove the 40-8 codes, which are all equipment violations. So by restricting it to only movement of vehicles, you leave out things like a person driving with no insurance. And of course, like I said, the open container, and even improper stopping or parking, which is a dangerous condition. And many people under the influence of alcohol that are driving will often pull up to a red light and pass out. And that would not be considered a movement of vehicle violation that would then, take away the person's ignition interlock permit. So I would ask the committee to really think about that because we couldn't support a bill that would allow a person to have an ignition interlock device and continue to retain their permit, and they have a conviction for open container while having that permit. Another issue was a concern about, would solicitors be inclined to reduce DUIs to reckless driving with this bill due to first offenders having ignition interlocks? And I can tell you that that would not be the case, and certainly would not be the case in Henry County. And I don't think it would be the case for any of my other fellow solicitors. The reasons that some of these DUI cases get reduced to reckless driving is because people are refusing to submit to a state test and refusing to submit to field sobriety evaluations. And so the state has zero to no evidence to proceed on the case. And there may be cases such as that where we have no choice but to reduce. But in those cases, when there's a reduction to reckless driving, they're required to do DUI school and the alcohol and drug assessment because it is a case that started and has alcohol or some other substance involved. So I wanted the members of the committee to know that the counseling is something that the solicitors and the prosecution take very seriously. And that is required if we have to reduce a case, but it would not be for ignition interlock devices. We believe these devices would be very helpful in reducing recidivism for DUIs. And then finally, I wanted to talk a little bit about the indigent section. There was some concerns about that. I did want to note that there may be people who have extremely good jobs prior to getting a DUI, but may lose that job as a result of the DUI. And so that might be something that you may consider in your thought process for reduced fee waivers for the indigent drivers. There was another section where we talked about allowing a limited permit for drug-related DUIs. I just wanted to bring up that cocaine is an illegal substance in and of itself. So allowing a permit then for a person with that is problematic. We believe, I believe it's code section 40-6-64 already allows a permit for people with drug DUIs. And I think that's all, unless you may have some questions.
Oh, we have no questions. Thanks for the testimony. As always, it's a pleasure having you here.
Thank you.
Even if you're not here, but you're online. Enjoyed your testimony. Next up, we have Frank Harris with Mothers Against Drunk Drivers.
Thank you, Mr. Chairman, for having this lengthy hearing today on this important legislation. And my name is Frank Harris, Director of State Government Affairs for Mothers Against Drunk Driving. And I've been with MAD for 14 years, and I have pushed for ignition interlock legislation in every state, including Georgia, in my time with MAD. And I've heard a lot of these arguments that have come up and a lot of these concerns, and they're all valid. You know, 3 years ago, actually, Representative McLaurin alluded to this. I mean, this issue came up before this committee with Chairman Abstration, when MAD was trying to get this included in the implied consent fix due to a state Supreme Court ruling. That did not happen. Then COVID happened. So this idea has come before this committee. That was 3 years ago. So it's good to be here again. Now, this is another tool in the toolbox, and it's a tool utilized in 34 states, which was mentioned. And it's already used in Georgia. And yes, a judge could order an interlock for a first offender, but they aren't. Just like in 1980, where police could arrest somebody who's driving drunk for reckless driving, but they didn't a lot. They just drove them home and gave them a pat on the back. To change behavior, you need to change the laws. And if the state of Georgia didn't realize the seriousness of DUI back in the day in other states, we wouldn't have seen a dramatic reduction in drunk driving deaths from the early that we saw in the early 80s to the late 90s. And also, there was concern that somehow this is going to be bad for small businesses that provide interlock devices. Again, there's 110 locations or something like that, according to DDS, that install these devices. I mean, what we've seen, again, with our experience in other states, if you build it, they will come. And this law would provide for more service providers. So, and again, the indigent program is so very critical to ensuring that no one is left behind who gets a DUI. And also, none of these laws have been ruled unconstitutional, the indigent program language. And again, this is a step forward. We'd love to see interlocks included in plea agreements. But right now, the fact that judges can continue pleading down to reckless driving, allowing for that, that shows A, that there is judicial discretion still, and B, this law doesn't change the judge's ability to allow for plea agreements. So that's still going to happen regardless. But what this bill will do, it will save lives, as it's been proven to in other states, and will create a future of no more victims. And we urge this committee to advance this bill. And thank you again, Mr. Chairman, members of the committee, for your time.
Thank you, Mr. Harris. I think that is everybody on the list. Anybody else in here that didn't get put on the list? We have batted this thing back and forth, and I certainly appreciate every member coming in here to speak to the bill. I'm going to leave the last word with Chairman Hitchens. Most pieces that come in here, we usually do a subcommittee, then a full committee hearing. We've suspended with subcommittee because we're so late. So we're trying to move things quickly as possible. If the author wouldn't mind, let me take this under consideration and then offering it up in another committee to move forward. If that is what we come to, I'd appreciate that, Mr. Chairman.
Well, I appreciate that. And I appreciate the opportunity to be here today. You know, this is something that, as I've already said, I've dealt with for over 50 years now, and it's significantly important. DUIs cause unimaginable damage, pain, suffering, emotional damage, financial damage. And unfortunately, most of the people that it involves, not all, but most of them are innocent people. You heard them talk about children in vehicles, children just innocent people. And I almost had it happen to me one time. I was on the interstate when a car came in the other direction, and he was obviously very drunk. I was working and stopped him, and I had another trooper that was disabled that was stopped along. I was trying to catch a horse along the interstate, and he was parked off of the road on a Saturday night at about 2 o'clock in the morning. And a car was picked up on radar on the other side of the road running 76 miles an hour, which wasn't really speeding on the interstate. But he was following the taillights of the vehicle in front of him, and the trooper that was sitting alongside the road on the grass, he thought he was following. He ran into the back of him running 76 miles an hour. When he was stopped, broke his back and crippled him for life. And he was significantly drunk. But there's a lot of pain, horror, and heartache to go along with this. And my only issue here, I don't care what you do with the bill, is that we make it safer for the citizens of Georgia. It's gone on for too long, and it's a tool in the toolbox. It's just one of many. I've watched this since 1969, when all they did was get a pat on the back and say, please don't do this again.
I agree with you. We do need to make it safer for Georgians, and I appreciate your giving us a little levity to deal with a very large measure. And I appreciate everyone that came to speak to the bill today. And as soon as I get done, I'll be in touch with you, Chairman Hitchens. I appreciate you coming here this morning.
Thank you all.
Thank you. We've got a few bills that have already been heard in subcommittee. I'm going to pull them first. House Bill 1433, Criminal Justice Coordinating Council, revise and update. Chairman Ballinger, would you unmute yourself and present this bill?
Okay, Mr. Chairman, I appreciate you hearing me and the patience and that you've had and also the graciousness with which you presented it in subcommittee for me. The substantive changes are on lines 36 through 42. You'll see in line 34 through 36, we're striking antiquated language whenever we're specifying a member of the board. And we're just adding kind of new updated language with expertise and competence in preventing and addressing mental health and substance abuse issues. And then it also requires representatives of victims or witness advocacy groups, including, like our prosecutors, they always have victim witness programs and that sort of thing. So it would be somebody like that to be added to the board. And so those are the changes on line 36 through 42. And then we have a slight change on line 45. We're changing it to from 24, we're striking 24, making it at least 28 years of age. And then on 48 through 50, there is a requirement that 3 members shall have been or shall currently be under the jurisdiction of juvenile justice, but it provides for some flexibility there, or if not feasible and in appropriate circumstances, shall be a parent or guardian of a person who has been or currently under the jurisdiction of the juvenile justice system. So it's just really striking some old antiquated language in membership in the board and adding some new updated language, just bringing it in conformance to the federal requirements. And I'll be happy to answer any questions.
Chairman Ballinger, these provisions are in accordance with the federal language that's required to receive these grants?
Yes, sir. It is required from them. Yes.
Okay. Got one question blinking. Representative McLaurin.
Thanks, Mr. Chairman. Thanks, Madam Chair. I'm sort of new to this, so I guess I'm just trying to understand which specific changes are required for the federal grant. Is it to take away juvenile members from the board, or is it to add the representatives of the advocacy groups, or both?
So it's just basically like the individuals that are getting struck, individuals with special experience or competence in addressing problems related to learning disability, emotional difficulties, child abuse and neglect, and youth violence. Those, you'll see those still in there. Representatives of victim or witness advocacy groups, at least one individual with experience in addressing challenges of sexual abuse, which was part of that was struck, the child abuse and neglect, and was added back in later, including sexual abuse and exploitation, trauma. We're fairly new to the game with regards to trauma. So, that's one of the kind of the new things that got added in, and particularly the needs of youth who experience disproportionate levels of sexual abuse, exploitation, and trauma before they enter the juvenile justice system. So we're just really kind of bringing the language and the membership up to what we now recognize that we need on the board with more specifics.
Okay. And thanks for that clarity, although I'm not quite sure that answers my question about the grants. I mean, are we at risk of either not getting grants or losing them, or what's the specific hook that we're trying to capture?
We don't necessarily, in order to, and perhaps I know Director Neal is there, and perhaps he could answer it better than I could. But it's really just bringing us in conformity with the federal system. The federals require certain memberships and certain voices be heard on these boards. And we're just bringing that into conformance with the federal system.
Okay, and I do have a couple more questions, but Mr. Chairman, I would request that Director Neal weigh in if he can.
Director Neal.
Thank you, Mr. Chairman. Jay Neal, Executive Director of the Criminal Justice Coordinating Council. One thing I would like to mention, Mr. Chairman, is that our state advisory group is currently already in compliance with the federal requirements, but the state statute doesn't line up with the federal statute. So this will not change the current makeup of the board. It just changes the state statute so that the state statute matches what we have.
So I guess
does that make sense?
If that's true, then I'm curious whether we've, I guess, been violating the state statute by not having juvenile members or youth workers involved.
We do have those members we do have those juvenile members on our state advisory group.
Okay. And so I guess this would allow the flexibility to not have youth or juvenile members on the board at all, right?
This still prefers youth members, but allows for when not. Let me pull the bill. On line 48, 47, 48, at least 3 members shall have been or currently be under the jurisdiction of the juvenile justice system or state, or if not feasible, in an appropriate circumstance, shall be a parent or guardian of a person. So if not feasible, then we can have a parent or guardian of a person that's been under the jurisdiction.
Okay. Yeah, because I mean, I see the change at line 30 and I see those changes. And I guess the inference I'm making looking at that is that there was some decision to try to move away from having youth or juvenile members. And I was curious if that were the case, and if so, if there were a reason for that.
I don't believe it's the intention to move away from those youth or those juveniles. I think we have had some considerable challenges in being able to find the number of youth that are necessary to be on the state advisory group. It's my understanding that we do have those youth members on there. I think some states have more challenges than we do. The federal government is now allowing for that flexibility. We will still endeavor to have the youth voice on the state advisory groups.
I hope it's not awkward to ask. Could you describe what the challenges are in having youth involvement?
If I may, Mr. Director, as somebody who's a member of the state advisory group, we are consistently and constantly doing recruitment in high schools and in colleges, trying to get folks involved. But, the idea of coming in, sitting in a boring room with a boring meeting with a bunch of bureaucrats, the 18-year-old is not really happy or eager to do that. But we are consistently, and their voices are heard. And we do incorporate them as much as we can into the activities of the special advisory group.
Okay. I think that's helpful to kind of just get a sense of what that's about. So I appreciate that, Madam Chair. And I think that's all the questions I have.
Thank you, Representative McLaurin. A former esteemed member of this committee, Bert
Reeves, Chairman
Reeves.
Or-
Chairman Reeves, excuse me. I'm losing all train of thought here. He sent an email in support of this bill. He also serves on the board with you. Is that true, Chairman Ballinger?
That is correct.
And in his overview, it aligns with what you said, and that he's just we're trying to give some more options because as many of us know, it's hard to get public participation, and many of our board committees and such. So that's what he's saying is sort of aligning exactly what you're saying, giving us an opportunity to have an expanded pool of candidates for the board. And I don't think that the underlying impetus for the bill is to do away with the minors, but I think it's just so that we have enough people to serve. So I appreciate that.
And if I may, to respond to Representative McLaurin, other comment, without bringing our coming into compliance, there is the risk of losing up to 20% of the grant. So this does help protect that grant.
Thank you. Anybody, any other questions? No other questions. Thank you, Director.
Thank
If there are no other questions, no one to speak to the bill, I'll entertain a motion. Move to pass in a second. Any discussion? Any amendments? All those in favor signify by saying aye.
Aye.
All those opposed? The measure passes the rules. Congratulations. Thank you, Chairman Bellinger. We got that one. House Bill 1354, Representative Holcomb. This is a bill that's come to subcommittee. I'm going to ask the subcommittee chair to give us a report of subcommittee.
Thank you, Mr. Chairman. Mr. Chairman, this bill was favorably reported by the subcommittee. I appreciate Representative Holcomb working with us and thinking through these things. And again, our recommendation was do pass.
Thank you. Representative Holcomb.
Thank you. Thank you, Mr. Chairman. I present to you this morning or this afternoon, the Wrongful Conviction Compensation Act. The purpose behind this legislation is to set forth clear policy and standards for addressing when individuals are wrongly convicted. Right now, the state uses an ad hoc process, and this would give greater clarity in terms of the circumstances under which this would be appropriate and set forth a review panel and the legal standard. Working through the bill, the meat of it begins on page 3. It defines exonerated. We've included helpful recommendations from the Prosecuting Attorneys Council on that. This legislation would create the Wrongful Conviction Compensation Review Panel, whose job it would be to evaluate these claims. The individuals of that are defined on page 4. And then the legal standard in terms of what a person would need to satisfy in order to be compensated for being wrongfully convicted is in section 28-5-112, which begins on line 85 of the bill on page 4 and goes runs until line 102 on page 102. Line 102. And effectively, they have to prove that they're innocent. And so it sets forth those standards. It's a preponderance of the evidence standard and the various factors that would be considered. And then in terms of the payment, we're setting a floor of 50,000 and a cap of 100,000. A survey across the country has found that generally 70,000 is around where most states are, as well as the federal government, if you were to allow for inflation. And the major change that I want to highlight from subcommittee to full committee is found on page 8, and it has to do with the compensation. And these were recommendations from the chairman of the Appropriations Committee. He recommended that the payment be in the form of an annuity instead of just a cash payment, and then to provide some guidance in terms of that annuity. The panel could recommend a cash payment of up to 25% of the total award, and then depending on the age of the claimant, it would impact the time period. So somebody who is under 60 years of age, it could be an annuity of up to 20 years. If it's an individual who is 60 years or older, it would be a 10-year annuity, which would reflect potential lifespan on that. So that's the major change. And of note, for the individual compensation resolutions that are proceeding this year, my understanding is that's the formula that has been employed for those individuals. And then lastly, the other minor change from subcommittee to full committee is found in lines 208 to 214 on page 9. And this addressed the concern of if there's an exonerated person through dismissal or nolle pros, is that they're not compensated until the statutory deadline for representation is passed. So we think that we've fixed and addressed all of the concerns, and I'd be happy to dig deeper should that be the will of the committee. Thank you.
Thank you, Representative Holcomb. I've got 2 questions blanking here. Chairman Smith.
Yes, Representative Holcomb, thank you. I understand the concern of Ways and Means. I really like this bill the way it was written with the compensation before. I
did too. I did too.
really do not like it now. And would wonder if you'd be amenable to going back to how it was written before.
I would be, Mr. Chairman. I fear that it will make it really difficult to pass the floor if we make that change, though.
Follow up. Remind me, we had 2 bills dealing with this issue last year in the House.
I don't recall.
There were, I'm being told 3, thank y'all. And I want to say those passed with overwhelming majorities. And so, although I been there before with the criminal justice bill, I understand the concern there. But I would wonder if you'd be amenable to going back to the way it was written, though. Just, and may require some explanation on members. I mean, I'll sure advocate for it within the majority caucus. Just if you'd be amenable to that.
I have no opposition to it, Mr. Chairman. I would just restate that my sense was that the feelings were very strong from the chairman of appropriations in terms of having it this way. So,
and Mr. Chair, if I could just follow up one more time, I think I've really pressed this issue. If we could still, under our legislative powers, come back and still introduce a bill like we have before, like we did last year in particularly. If we could still do that by putting it in the statute this way, would that, in your opinion, limit us to only awards within the percentages laid out here?
It does. And there is another option, which would be if we reverted back to then have that go to rulemaking, but without getting into the conversations outside of here too strong, is I made that representation in what you have before you is.
Let's do this. Let's not vote on this. Let's go back and have a conversation with Chair Appropriations and Chairman Smith and see if we can find something that's a middle ground, and see if we can do that quickly, so we can move forward on the bill. Do you still have a question?
Thanks, Mr. Chairman. Thanks, Rep. Holcomb. This is obviously long overdue, super important piece of legislation, and maybe one thing that will help us sort of be comfortable with whatever we land on. I mean, my understanding is the review panel, the board apply criteria and make a recommendation, but ultimately this is committed to the sound discretion of the Chief Justice in terms of whether to accept that recommendation or not. And to do so would basically be in conformity with the Chief Justice's budgeting for that year. And so the Chief Justice would accept the recommendation if it fit within the court's budgeting plan, and the Chief Justice and the other justices had an agreement with the appropriations chairs as necessary to make it happen. So I guess what I'm asking is, it's committed to the justice's discretion, and ultimately they would resolve it as necessary with regard to budgeting. Is that basically accurate?
Correct.
Subject to appropriations. Correct. Thank you.
Thank you. Let's circle up on this
Okay.
soon after this hearing, whenever we get done here with. Thank you. Moving on. Chairman Gaines, House Bill 1452.
Thank you, Mr. Chairman. Great, always great to be back with you. House Bill 1452, which we had in subcommittee, very simple change that last year we had important legislation to protect victims of dating violence with temporary protective order, providing a dating violence temporary protective order. Last year, we worked through the language quite a bit. This just allows for within 12 months after a dating relationship having occurred. It came to us after, I mentioned this in subcommittee, but a UGA student who approached us and let us know about her situation, and so that inspired this bill, and hope we can move forward on it. Have Rebecca Grice, solicitor from Macon Bibb, here with us again, and if there's questions, we're happy to answer them.
Thank you, Chairman Gaines. I as I understand it, we're moving the six months to 12 months, so 1 year after a dating relationship, allowing this civil protective order to be addressed for these victims. That's correct, right?
That's right.
That's what we're doing. Nothing else.
That's right.
Don't have any ideas to do anything in the Senate or anything.
No. Is it?
All right. Anybody have any questions for Chairman Gaines? No questions. We have one person online, Rebecca Grist. Oh, okay. All right. That's not the other one. Go ahead.
And anyway, if you really don't have any more questions, I did get some answers to your question about how many had been filed and how we were keeping track of things. Do you still want answers
Yes.
to that? Okay. The answer from Administrative Office of the Courts was that actually the forms that would be able to have someone file under the Dating Violence Protective Order Act as opposed to the Family Violence Protective Order Act actually only went online last Thursday, March the 3rd. So everybody has been kind of cutting and pasting and scratching out in order to be able to file them. There weren't the proper codes were not in the computer system to keep track of that. So we do not have those numbers yet. And probably, I don't know what the Administrative Office of the Courts and the Judicial Council, what their, when they go and pull those numbers and that type of thing, but we just do not have them yet. Just as a straw poll, I know that Judge Manning that testified a good bit last year, we reached out to her. She said that she's had several dating violence protective order cases, and she has had to deny some because of this look back period only being 6 months as opposed to a year.
Mr. Chair, I was just going to give the report of our committee.
Please do.
Mr. Chairman, this bill was favorably reported from our committee. I think that it furthers the intent of this committee as we saw last year and helps us to accomplish the purpose that we have seen needs to be accomplished to effectuate what we tried last year.
Thank you, Mr. Chairman. Did you have anything else? I didn't mean to cut you off.
No, that was it.
Okay.
That was it. We talked a lot last year.
Representative McLaurin.
It's still flat. Mr. Chairman, thanks. I just got that sensation that it's an appropriate time
It is.
to make a motion. Well, I would move due pass then.
Move to pass. Got a second? Oh, I'm sorry. Do we have?
I apologize. I didn't know y'all were signed
All
up.
right. Hold on one second. Let me ask Jill? Maisie. All right, Maisie, come on up. I see that you've marked down most of the bills. Okay, all right.
Okay.
So not
Maybe we
numbered,
should have said
most
all
every bill that
of
we
your
speak to.
So this extending the look back period is a concern to us. But the far greater concern we have about this bill is the atmosphere surround the arguments for passing it. When we listened to the testimony from last week's subcommittee hearing, the allegations that were made are criminal. I mean, I believe Sister General Grist agrees with me about that there were sexual assaults alleged. There were mechanisms in place that could have been leveraged by the alleged victim in this case to secure the kind of protection that this order offers, that this temporary protection order offers through the criminal litigation system, criminal legal system. Now, we love the idea that a victim would prefer to use the civil legal system to get their protections versus coming into the criminal system, of course. But to the extent that we have found sometimes the testimony to support these types of bills raises concerns for us that maybe the actors in the system don't really understand how to apply the laws that you all have already put on the books for them to use. That there's no reason why the allegations that were raised here last week wouldn't amount to engagement of the criminal legal system on that person's behalf the statute of limitations for those crimes is 2 years. So just to the extent that the look back period is a policy matter that you all need to make a decision about, that's a different issue. But continuing to make policy decisions based on factual scenarios that are already handled under our code just feels problematic to us, and it continues to happen time and time again.
Thank you. You got a question?
Ms. Karen, thank you. And to my good friend who I agree with so much of the time, if we could air this maybe just a tiny bit, I think it would be helpful. I mean, would you agree there might, and I'm a signer, so I'm super biased, right, in favor of the bill. Would you agree that there are circumstances where the policy concern, the thing that the victim wants is just to get relief quickly and not necessarily fire up a huge process? And to your exact point, I mean, isn't it possible in your mind that there are some circumstances where if the only option were to go through the criminal system, then essentially you'd have to basically bring a charge when that isn't even on the table as something that the victim needs or wants in that moment, right?
Absolutely. And I think, and there's with some hesitance that we speak today because of that reality, right? I mean, we'll talk later about another bill that's on your calendar relative to this as well. I mean, if the real protection that's needed is a protective order and is not some kind of punishment, then yes, we're all for making that more accessible. The concern is just understanding the atmospherics that go into these decisions and the reality that the scenarios that are being raised are criminal scenarios. And if we want to limit it, I mean, I guess the bigger question is, do we want to limit people to the civil proceedings or not? I mean, I know you probably don't, right? But it's telling us, wouldn't you rather them do this, but not, there's still access to both options. And within the criminal legal system, the person against whom the allegations are raised has a right to counsel to represent them. They do not have that in the protective order context, and they have to do it all on their own. And it's clear that there are actors in the system that are there to help the alleged victims that are bringing these protective order claims. So there is a distinction to be made about the protections afforded to someone who's being accused of the bad behavior in the civil versus the criminal context.
And I guess you could weigh in on this.
Yeah, I'll be glad to. And I've gotten a little bit more follow-up information. We had a private conversation about this while we were sitting here this morning. Number one, there was a police report filed here. Being able to charge someone and prove them guilty beyond a reasonable doubt is a very different standard than the civil standard. In this particular case, the breakup had occurred in February. It was not until the victim, actually, she said, saw a TikTok video with a woman talking about a similar experience and went, oh my gosh, that's what happened. And so that's when, and that was in July, late July. And so we were already almost at 6 months at that point before psychologically she was like, oh gosh, that's what happened. And so that's not a unique experience. And this request is not about one particular case. What this is that it came to Representative Gaines's attention because someone in his district reached out to him. Like I said, we did some informal polling because that's what's available to us at this point. There are other cases throughout the state where the protective order has to be denied simply because of the look back time period. And just to submit once again that 6 months is not long enough. You're looking at the dynamics of family violence, of dating relationship violence, where these people, there's a lot of love there too. It didn't just happen overnight that suddenly you wouldn't start dating someone who was ugly to you up front. So it's something that happens over a period of time. And that is, the proven psychological element of this entire scenario, there's love there. And you don't want to believe that somebody would try to manipulate you. And you don't want to believe the worst of somebody that you love. And so it can take getting out of that. It takes a lot to get out of a relationship like that. And when you're on the other side of it, it's not an automatic, oh gosh, I'm going straight to the courts with this. You want it to kind of die down on its own. If you give it a year, you're giving an opportunity to victims that they need that time.
And thanks for that.
Uh-huh.
And I think either way, no matter what the committee does,
Yeah.
super important to air this. And ultimately, I think where I fall is that the standards being different, it provides for coverage in a case where you may not get it. But I am thankful. So
correct.
Thank you.
Thank you, Ms. Lim. Is there anybody else signed up to speak? No one else has not signed up to speak. The time is now for a motion. If there anybody there is motion.
Motion do pass.
Motion do pass in a second. All those in favor signify by saying aye.
Aye.
Are there any opposed? No, there are none opposed. So on passage of, make sure I got the right LC number. Passage of House Bill 1452, LC 280448. That's passed on the rules.
Thank you.
Thank you very much.
There you go. All right. Representative Gaines is a glutton for punishment.
Aye.
He has. Was that grabbing?
Just making sure it was recorded, Mr. Chairman.
Thank you. Thank you, Representative Gravely. All right. So the next one we have,
Either one works.
neither one was. All right. All right. I'm going to go to House Bill 689. This is a bill that you dropped last session. Is that
That's right.
correct? And so you're going to have to flesh this out and to explain to the committee what it does and what you're doing.
Sure. So House Bill 689 is a pretty simple bill. Some cleanup language on two different pieces of legislation we passed in the last couple of years. The first section relates to human trafficking survivors who've had their cases vacated under the Survivors First Act that we passed. I believe that was last year. It fixes an unintentional requirement these survivors had to wait 2 years before asking a court to restrict and seal their offense. I don't believe that waiting period was ever intended. So this just fixes that issue and allows them to apply for vacature and move forward immediately. The second section is a cleanup from Senate Bill 288 that I worked on, I don't know, last year, the year before, that we passed in the Senate and House that allowed record restrictions here in Georgia for misdemeanor crimes. This was just some language making sure criminal justice agencies always have access to restricted and sealed records. And that was something that we believe they already do, but there was just language that was asked for to make that clarity. And that was something I committed to either last year or the year before to add in. So that's what the bill does and addresses those two issues.
Thank you, Chairman Gaines. Is there anybody, Gecko? This is not one of the most of the bills. Back. You guys are good. We've got Wade Askew online. Oh, excuse me. Made it. Well, you didn't think it was going to be a 3-hour hearing. That's why.
Thank you, Mr. Chairman. Thank you, representatives of the committee. Wade Askew, I'm a supervising attorney at Georgia Justice Project, and just want to echo what Chairman Gaines said. We're in support of this bill. It's just a minor bit of cleanup from what we've been working on for a few years.
Very good. Got a question from Chairman Smith.
Mr. Chair, just at the appropriate time.
Now is the appropriate time unless there are any questions for Mr. Askew. We got to move, do pass. We have a second. We have a second. Any discussion? All those in favor signify by saying aye.
Aye.
Online.
Aye.
All right. Any opposed? Like sign. The measure passes on the rules.
Thank you.
Chairman Gaines. What do you know? We got another one for you there, Mr. Gaines. House Bill 1502, LC 280486. Representative Gaines, excuse me, Chairman Gaines, would you present the bill?
Sure. Well, I know y'all have not talked about DUI enough today, so I wanted to give you a little bit more to discuss. House Bill 1502 would, for a person convicted of a DUI, they would be required to reimburse that agency, the governmental entity that incurred the cost of the blood alcohol test, which is about $125 per test. We pulled that data, for example, from Savannah PD. It's they spend about $30,000 in the blood alcohol test, about $125 a test. So it would require upon conviction as part of their sentencing that they would be required to reimburse the agency for the blood alcohol tests.
We talking blood alcohol or
That's right.
Any other testing?
Just blood alcohol test.
Just blood alcohol. So this wouldn't be for DUI drugs.
Correct.
Okay. Is that all you wanted to say before I open
That's
the
it.
questions?
Yep.
All right. Representative McLaurin.
Thanks, Mr. Chairman. Yeah, people turn on you, on a dime. This is me right now. So Chairman, happy that you got the other bills through, but I have serious concerns about this one.
I thought you might.
You thought I might. I mean, so here's, I think, what we're looking at with something like this, right? Obviously, with criminal convictions, there come a host of fines and fees. And I think a lot of times those fines and fees are tied to programs, right? Funds that fund particular policy goals related to either, restitution of victims or, speaking off the top of my head, I'm not gonna be able to list everything, the garden variety stuff. But one concern I have is that there might be sort of a slippery slope with something like this, right? Where, there's obviously lots of costs attendant to law enforcement. It costs, gas in the trooper's tank, gas tank for the cruiser. I'm sure the handcuffs cost money. Like one thing I worry about is, I know that the context of DUI, given all the testimony we've heard today, is especially sensitive one where people feel like we need to emphasize responsibility of somebody who offends. But I just am wondering, do you have a sense of, I'm kind of asking, I guess, a philosophical question. I mean, where would you draw the line with asking for a person who's convicted to reimburse the state for the costs of law enforcement bringing that person to conviction? Do you have kind of a line in the sand you can suggest? Because that would be my concern with starting to go down
Well,
that road.
this is clearly a hard and fast expense that they're incurring. I mean, I know what you're saying is gas, mileage, and those sort of things. I mean, that's I wouldn't say that's as clear cut because how many miles they have to drive and those sort of things. So I think this is a clear cost that the agencies are incurring. And that's why I think this makes sense to make sure that those agencies are reimbursed on this particular case. I see where you're headed, but this is a clear cost that I think makes sense, for someone who has been convicted of a DUI to reimburse that cost.
Can you, and I failed the pop quiz just a moment ago, so it's not totally fair for me to impose it on you, but you did bring the bill. Can you name a comparable fine or fee attendant to conviction that anybody pays that basically reimburses the state for investigative costs related to the crime of conviction? Is there any analogy you know of under current law?
While sitting here with you, I can't come up with anything off the top of my head. I could sit, maybe with more time I could, and maybe once it's on the floor, we can talk about it then too.
I'll just lose, but yeah, we could, that's fine.
But
I want to ask the question.
No,
because
that's
I think
a fair
it's an important
question.
question.
But again, these are folks who've chosen to drive under the influence, and I think it's $125 to save our police agencies, and we talk about $30,000 for Savannah PD, what that could do, whether it's hired another, helping fund part of another officer's salary or something like that. I think that's a better use of, instead of taking it from taxpayer dollars, it's taking it from people who've driven under the influence.
Understand your position. So thanks for answering the questions.
Absolutely.
And from Vice Chairman Smith.
Thank you, Mr. Chairman. Chairman Gaines, thank you for those two previous bills. We might not get along so well on these. That last comment you made was interesting about the revenue. Is this a revenue bill of sorts?
Well, I think it's two different things. One, it's, certainly punishing individuals who've driven under the influence of alcohol. And then secondly, it is making sure that agencies that have incurred these costs to have those costs reimbursed from individuals who've been convicted of a DUI.
So you're familiar with what happens if you refuse to take that test, correct?
I am.
Okay, all right. And so,
And I understand there's a lot of, y'all are the lawyers, I'm not. So, but I understand
Right.
there's a lot of discussion about that in general right now.
right, and just to flesh that out, I mean, a situation that you're basically feeling forced into, whether you're guilty of it or not. And just, this is a policy consideration. This is really something we need to think about as to whether, is this right to enforce this cost on them? And just, that's my thought on the matter.
No, and I appreciate that. And I guess I would argue, again, these individuals have chosen to drive under the influence and, $125 in addition to, I know there's already a lot of costs associated with DUI, but I certainly think this makes sense to make sure our agencies are reimbursed for that cost.
Representative Sains.
Thank you, Mr. Chairman. I differentiate from my colleagues. I had immense respect for the two last bills you brought forward. I have immense respect for this one. To me, it's a question about burden, and coming from an area that does have, like you mentioned, Savannah, a higher degree of tourism traffic, and those individuals are coming into our communities, and that burden of a positive blood test as evidenced by conviction. I don't think it's inappropriate to place that burden out of the citizens that they've endangered and into the hands of that individual who's been convicted. Could you speak to when is the most? So my understanding that during the implied consent, blood is now the only test that can be utilized without due to the judgment of the breathalyzer being a search and seizure violation. Can you speak to what is it at the time of the roadside that the blood tests are most likely done? Is it the deputy who's stopping the individual who's most likely to order that blood test or request
I don't know off the top of my head. Terry, do you know the answer to that question? We're calling. So the question was, when is on a DUI stop, when is the blood alcohol test most likely to be administered? Is it at the site or is it back after?
From my perspective, I might ask Chief Harris too, but from our perspective, it's going to be in the jail setting.
Okay.
It's going to be a cost out of the sheriff's office budget, or in the case of Savannah PD and the larger PDs, they may be doing it prior to going to jail. I just don't know the answer to that.
And I ask that because as a deputy, I don't think I've ever thought of the cost of a blood test, but I do know that as a system, and those jail administrators do look at their budget restrictions. And I would hate to think that some of our communities are less protected from ensuring conviction of DUIs by those budgetary burdens. So I appreciate you bringing this forward.
Thank you.
Vice Chairman Smith, you wave. Well, Chairman Gaines, 2 for 3 is pretty good.
Let's go 3 for 3. I like the perfect match.
Let's do this. Let's talk offline about this bill and see if we can't work with some of the concerns that have been brought up here. I too share a little bit of concern about a bill that does what you're doing. I think the idea certainly to punish those that are knowingly doing something like this is one thing, but this is a new concept where the law enforcement would be administering the test and then, well, I guess the law enforcement, they just draw the blood. Is that true? And the test is done, the test is done at the hospital or at the crime lab.
Yeah. So like, for example, it's like a bill from an ambulance service. It's about 25 pages long of $125 charges, for example, in Savannah that add up to $30,000. And that was just one ambulance service where that cost was incurred. So that's right.
Well, I like the idea for the bill. I'd like to kick it around a little bit, and I haven't had the opportunity to touch base with some of the stakeholders here and figure out where they are on it. Is there anybody else here to speak to this bill? Gatco? Let's go, Judge. Terry, you go to one?
Yes, sir.
Yes, sir.
Just sheriffs will support this bill, and as far as it being a revenue bill, I think we would look at it more in the nature of a cost avoidance bill, and not to use a cliche, but a pay to play bill on behalf of the offenders. So any consideration you can give, and we understand both sides as well. So, you know, there's a lot we'd like to get to help run jails and sheriff's offices and police departments throughout the state, and this would help. But nonetheless, thank you for hearing from me today.
Terry, is there any way you can get us some data spread throughout the state as to what the figure is here, how it's being that a cost to multiple different areas of the state, the cost of the test?
Well, yeah, sure. I can ask the question. I don't know how quickly we can respond, and we could get maybe the chiefs to help us too. We'll try to do something fairly quickly though. Just, you know, talking about the cost of the test and where it's administered.
Well, you know, Chairman Gaines has got Savannah's. I was going to see if you could get some in some of the other areas and see if we could kind of get an idea what this number is. That'd be helpful.
Thank you. Yes, sir.
I mean, I would guess that it's quite a bit, but we'll try to get some data on that.
Okay. Representative Sains.
Just a quick comment to the bill, and I understand it'll be discussed off session. And I don't know if this would be allowable, but possibly to make it more amenable to the committee, if it would be appropriate to modify line 13 from shall to may, is if it's constitutional to let the court decide if it's appropriate in those instances. It would also let court, you know, areas where there is an influx, Georgia, Florida weekend, areas that might be a policy perspective on that court to make sure that, again, our public safety agencies aren't making a decision on enforcing our DUI laws based on their budgetary restraints.
Thank you. I got one more person signed up, Gatco.
Don't take off my glasses, I take off my mask. Confusion. Good afternoon, Mr. Chairman and members of the committee. My name is Jill Travis. I'm the Executive Director of the Georgia Association of Criminal Defense Lawyers. What our concern about the bill has been brought forward by many of the committee members that have spoken already, but even more so, I think that this is already law. I don't think you need a change in the law. I think that if you look at 1714 and the definition of damages, the definition of victim, and the definition of restitution, and you look at the way that it's collected, a prosecutor under today's law could seek this as restitution. And if they did seek it as restitution, then you have the process that's in 1714. Unfortunately, this bill sort of conflates the issue. It puts it in a different code section, so it doesn't fall squarely under restitution. It is broad in the way that it's assessed. It talks about extraneous things that are not exactly the same as what's in 1714. For example, you know, damages that can be collected via restitution is anything you could get in a personal injury case. So in a personal injury case, if somebody was hospitalized and there was, you know, had to be blood draws, you could collect that. So with it being already the law, we'd ask that the committee pass on passing this legislation and let this be an educational issue and not a legislative issue, because especially of where it is placed in the code.
May I ask a question?
Sure.
Are you familiar with any time prosecutors ever actually asked for that?
No, sir.
Okay.
That's why I say it's education, not legislation.
And again, I'm no lawyer, so I'm legitimately curious. As I understand, this would allow the court as part of the sentencing, but what you're suggesting is that the prosecutor under current law versus explain to me the difference.
Well, it starts when any kind of case is resolved, before the court, before there's negotiations, right? And as part of negotiations, it can include restitution. Let's say in a battery case, there's some hospital bills. The parties can negotiate what that's going to be, and then it's up to the judge to accept it. Or if they are arguing about what the damage is, something stolen and the value of the property, then the judge decides it. Similarly, in this instance, the prosecutor could say, I want to add on $125 for the blood test. And the defense could say, no, I don't want to agree to that. And then it would ultimately be up to the judge to make that decision. The definition of victim includes governmental entities. And so that's why I think that this is already covered in the law.
Representative Thorne.
Thanks, Mr. Chairman. This is fascinating. I mean, this is like, I think, some sort of like State Tort Claims Act type, question about analogical suits. And, if you were to imagine a hypothetical civil suit, what would it be like, right? Because I just scanned through this, and the definition of damages says means all special damages which a victim, which acknowledged that could be a governmental entity, but it has to be one that damages the victim could recover against an offender in a civil action based on the same act or acts for which the offender is sentenced, right? So, you imagine a hypothetical, so this is where I'm talking about State Tort Claims Act type thinking. You have to imagine a governmental entity trying to sue a DUI defendant for damages, and then claiming the incidental costs or the consequential damages of the blood test as like being damaged somehow. And what I wonder, and I think it's at a minimum ambiguous. I don't, just in terms of fair play, and even though I oppose this bill, acknowledging that I'm not quite sure that this captures it, at least from my read of it. Grant acknowledges it's like 2 seconds long, but that the question I think is open whether in a hypothetical analogous action that the government would bring against a DUI defendant, would the government have some sort of standing to say we were damaged by the act, which is the drunk driving, right? Would it be that the blood test is properly recognized as damage? So I guess all of that analysis would have to fall in favor of finding that to fit. And, it doesn't seem clear to me necessarily that that's already covered. But all that being said, I'm just being a nerd right now because I oppose the bill. So, Chairman,
But you're still trying to help us out a little bit.
Chairman, if you want to, I could buy into subterfuge and, go completely with the argument that you don't need to do this, but, I think it's ambiguous, right? I don't know that current law necessarily covers it, but to her point, I think it might. It's hard to say.
Thank you, Representative McLaurin. Let's get a couple more figures out of this, Chairman
good.
Gaines, and then I want to, Robert, do you guys have any take on this restitution issue?
No, sir, other than to point out that you guys did in 17, we're not legislature in 17-12-51 does this to public defenders. So everyone's represented by public defenders, the court doesn't have the ability to demand the application fee be paid back as a condition of probation. Hardly ever happens because, after all, they're indigent. So we're trying to fund a part of the criminal justice system on the backs of those who cannot pay and afford it. But so there is a precedent of this, but I would point out that it's not really a good one.
Sure.
But as to the bill itself, we're taking no position.
Very good. Thank you, Robert. Chairman Gaines, I appreciate you
Thank
coming.
you.
Let's keep working on this one and see if we can't find us somewhere to put this. All right.
Appreciate it. Thank you.
Thank you, Chairman Gaines. All right, folks, we got 2 more bills. Is Representative Maynard in here? All right. Representative Maynard, you've got a committee substitute, is that correct?
Yes.
What's the number?
7. Yes.
Okay. 0568S.
Yes.
Chairman Maynard, go ahead and present your bill. I've got one person to speak to the bill. And appreciate you coming.
Thank you, Chair.
So this bill was, and I'm going to be way quicker than everybody else that was here. This bill was heard in subcommittee last year. We did some work on it. So I won't go into all the statistics about stalking. If you were to read the statistics, it would just say that it's a serious crime, not only just in Georgia, but in the nation. And I'm thankful that the HRBO office has done an extensive research project for me on stalking that you should have in your folders that just talks about the statistics. And also what I asked them is to give me information on best practices for stalking. What I have found over the past 3 years, just being a victim of stalking myself, is that there are numerous loopholes in the system that do not protect the victims. And so this is another reason why this bill has come forward. And I did talk to Terry Norris with the Sheriff's Association, and with an amendment, he would be in support of the bill. On line 101 through 106, instead of it saying the GBI, we would just change that to GCIC on 101. On 102, it would say police departments and county sheriff's offices to ensure that the family violence, and then I'm going to put and stalking reports.
Oh, what else are you looking
Oh,
at?
you know what? He has the wrong.
I didn't have a substitute. I just had.
Okay.
None. Okay, sorry. Okay. Instead, let's go with line 134. And so instead of the GBI, it would say the GCIC. And let me give you that. The Georgia Council.
Information Center.
Georgia Crime Information Center shall periodically audit or cause to be audited all police departments and sheriff offices to ensure that the family violence and stalking reports. And so that would all stay the same. And the reason I'm adding family violence and stalking, I know in Fulton County, stalking is within the family violence department, but I can't say that it's in the family violence department in every single county throughout Georgia. And also on line 136 to 137, that also would change from the GBI to GCIC. Those were the changes that the Sheriff's Department wanted me to make. Now, let's see. If you go back to, and I'm sorry, I'm flipping around, but I wanted to make sure I got Mr. Norris's amendments in. If you go to page 31 through 38, just looking at what's underlined, these are recommendations from the best practices that the policy analysts have found that are working throughout the state, not the state, but the nation. One thing I would like to say about that is the Department of Justice, as well as the GBI, they do not have enough data. And I can send these links to you. I've been waiting for my admin to bring the copies to me, but they do not have enough data on stalking in particular. And so in order for them to have that data, that is why we made the changes with the sheriff's office. And let's see, let's go to the next one. Again, lines 39 through 44, these are changes from the best practices that are from our policy analysts. For lines 57 through 61, recommendations from the policy analysts. And I want to point out something else in particular. Okay, if you go to lines 104 and 105, if you think about stalking, it is defined in code, and it is a repeated act that just keeps happening over and over and over. And in my case, 3 years. And so what happens right now, if the police come out and make a report, that incident goes into the police report. And if they stalk you again in 6 weeks, it's not considered a separate incident already if they've been showing this repeated pattern. So, for example, someone may stalk someone online. Someone may stalk someone by just following them all the time. Someone may stalk someone through another person. So already in the code, it says indirectly. And so what happens once the stalker realizes, okay, I can't do it this way anymore, then they just try another method. And I'm open to questions.
Representative Maynard, being as we have this late edition of the substitute, do you mind if we push this to the next meeting and let the sheriffs and PAC and GACTO get together and make sure the language, let them overview the language, and then we push it on and we'll hear it in the next meeting?
That's fine.
We got a 1:30 hard stop because Judy's in here, and there's one more bill in here that we've got to probably do the same thing with. Sensitive to the issue. I know that you've worked on this bill. I appreciate the work you've done on this bill. I just want to make sure with the last change that we don't rush through it and get something put in the code that is not what we intended.
Okay. And then I just found out today, I thought the substitute would be online, but apparently it won't be online until it goes through committee.
That's right. So Jill and Robert and Terry, if you guys need a copy of the substitute, we can grab it out of the office and run through it. And then let's make sure we don't get something through that is not complete, not the best. It's LC 480568S, LC 480568S.
Thank you, Mr. Chair.
Thank you, Representative Maynard. Representative Maynard, if you would get with those parties and make sure that they see your language and if it address any issues they've got, and maybe that you've already fixed the sheriff's issue, but let's see if we can get it worked up. Okay. Thank you. All right. We've got one more bill that we are adding to speak about. And I don't think Terry's going to speak to that bill as well. House Bill 1426. Is anybody here to speak to House Bill 1426?
Representative Moore's outside.
Representative Moore's out here.
This is the version just dropped from Legislative Council.
That's the newest version.
Yes.
Well, hey, let's do this. 1426 is the lowering of the level for ID. We've got a new substitute. Let's get everybody a copy of the substitute, and we've got a 3 o'clock holding for committee. And get some time to put your eyes on it. Let's look through it and then come up with your arguments, and let's see if we can figure out a way forward with the bill. And I think rather than doing that right now, and we've got 20 minutes starting in on that right now, and we've got 20 minutes till Chairman Administration steps in here and shuts us down. So let's go ahead and adjourn for Judy Non-Civil, and then everybody get a copy of the latest and greatest LC, and let's see if we can't get our heads together and figure something out. All right, with that, we'll